Please be seated. When a guest or relative comes to your house, what do you ask? Did you have your food? Would you like to have something? Or for that matter, where do you get your energy to do your day-to-day activity? It is through food. With that note, we will be dealing with food safety and standard legislation today. Good morning to one and all present here. I am Sneha JS from 6th semester BA LLB and I'll be anchoring the program today. I'm glad to welcome you all to this workshop on the topic Sensitizing Stakeholders on Food Safety and Standard Legislation on behalf of Karnataka Institute for Law and Parliamentary Reforms in association with BMS College of Law. There is no wealth like knowledge and no poverty like ignorance, said by Buddha. Today, I welcome you all to gain some knowledge from this workshop. Before we start, I would like to give a brief about KILPAR. Karnataka Institute for Law and Parliamentary Reform was set up for the Law Department in the year 2005. It is an institute set up on the executive grounds in pursuance of the policy and action plan approved by the State Cabinet meeting on 3rd March 2005. It is an institution set up as a new experiment by the state government with the objective of timely adoption of reform in the law and parliamentary practices by way of reviewing the existing laws in the state from time to time and suggesting corrections. The objective of the institution includes the suggestion of formation of new laws required for social progress. Therefore, KILPAR is functioning as a permanent body for the continuous reviews of law. I would also like to give a brief on BMS College of Law. BMS Educational Trust runs a highly reputed institution imparting quality education to more than 12,000 students in various fields including law, architecture, engineering, etc. BMS College of Law was started during the academic year of 1963 to 1964. It has a rich legacy of 58 years. It was founded by late Sri B.M. Srinivasaya, a great philanthropist, and Sir B.S. Narayan. The college is affiliated to Karnataka State Law University and is approved by the Bar Council of India, New Delhi. With an aim of imparting quality legal education, BMS College of Law has a strong foundation and infrastructure with highly qualified and dedicated team of faculty committed to providing world-class learning experience. The Consumer Law Advocacy and Research Center, CLARC, is established during 2019 by BMSCL with the assistance of Consumer Right, Education and Awareness Trust, CREAT. The primary object of CLARC is to help students and faculty to understand the emerging trends in the field of consumer protection. CLARC seeks to achieve this objective through conducting independent research, field studies and dissemination of information, publications, organizing seminars and workshops. It also intends to widen its network by involving other stakeholders and the general public. CLARC has achieved milestone by organizing programs addressing consumer rights issue. A documentation center has been established wherein books, journals and other materials on various topics like law, consumer protection, food safety, etc. are made available in the center. Invocation in general means a form of prayer invoking God's presence. It has always been a custom to start a program with invocation song. Today we have the invocation song by Sahana PS from 6th semester BCom LLB. I would like to welcome Sahana PS on stage.
शरणु सिद्धि विनायक शरणु विद्य प्रदायक शरणु पार्वती तनय मूर्ति शरणु मूषक वाहना शरणु 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 बाहुहस्तचतुष्टनिः अट्टमुत्तिनहारपदकनि बाहुहस्तचतुष्टनिः इट्टतोडुगिय हेमकङ्कण पाशाङ्कुशधारणी शरणु शरणु कुक्षिमहालम्बोधरणी इक्षुचापन गेलिदनी कुक्षिमहालम्बोधरणी इक्षुचापन गेलिदनी पक्षिवाहन सिरिपुरन्दर विठलना निजदासनी पक्षिवाहन सिरिपुरन्दर विठलना निजदासनी शरणु 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 शरणु
Thank you, Sahana. That was indeed a nice and melodious start. Now I would request Dr. Gayatri Bai S. Ma'am, Coordinator Clerk, to welcome the gathering.
A very good morning and a warm welcome to all the dignitaries on the dais and off the dais, and my dear participants and my dear colleagues also. It's my pleasure to welcome everyone to today's program, the one-day workshop on sensitizing the stakeholders on the food safety and standards legislation. We are proud to announce that today's workshop is being organized by BMS College of Law in association with KILPA. At the outset, I would like to welcome Shri Venkatesh Nayak T. Sir, the Principal Secretary to Government, Department of Law, Government of Karnataka, who is our chief guest for today's workshop. On behalf of KILPA, our law college, I extend a very warm welcome to you, sir. I request Principal Madam to hand over a sapling as a token of respect. Thank you, sir. Thank you, ma'am. Now I extend a warm welcome to Shri K. Dwarakanath Babu, sir, who is the Director, KILPA, and the guest of honor for today's workshop. I request Madam to welcome, sir. Thank you, sir. Thank you, ma'am. I also extend my warm welcome to Dr. Revaya Odia, sir, who is a research head, KILPA, to this workshop. Under his guidance, we are able to organize this workshop. Thank you very much.
Sir, ಸ್ವಲ್ಪ ಸೈಡ್ ಗ್ರಾಸ್ ಸ್ವಲ್ಪ ಗ್ರಾಸ್ ಅಪ್ ನೋಡಿ.
Thank you, sir. Thank you, ma'am. Now I extend a very warm welcome to Shri YG Muralidhar, sir, founder, CREED, and who is also a resource person for today's technical session. So I request Priyanka, madam, Thank you, sir. Thank you, ma'am. So now I extend a very warm welcome to our beloved Principal Madam to this workshop. I request Priyanka Madam to hand over a sapling and a memento as a token of respect. So I extend a very warm welcome to Priyanka Madam, a coordinator for this workshop. I request Principal Madam to welcome her by giving a memento and a sapling. Thank you, ma'am.
I request Principal Ma'am also to felicitate Gayatri Ma'am.
Thank you, ma'am. It's my pleasure to welcome all the participants from other colleges who are eagerly waiting to present their research paper on the theme specified in the workshop brochure. So a very warm welcome to all the participants. So apart from this, I extend a very warm welcome to my dear colleagues who are attending today's workshop. And last but not the least, I extend a very warm welcome to all my dear students for attending this inaugural program. So once again, I welcome one and all to this workshop. Thank you.
Thank you, ma'am. Now I would request the dignitaries to inaugurate today's workshop by lighting the lamp.
I request the participants to join. Paper presenters.
Thank you all. Now I would request Madhumita from 6th semester BCom LLB to introduce our chief guest, Venkatesh Nayak T. Sir, Principal Secretary of Government, Department of Law, Government of Karnataka.
Thanks, Neha. I'm profoundly delighted to take an opportunity to introduce the chief guest for the day. That's none other than the Venkatesh Nayak sir. We welcome you, sir. Sir was born on 1st July 1975 at Madakanipura, Chitradurga, and he has completed his primary, Aya school at Madakanipura. He has completed his secondary education, that is PUC, at Government Science College of Chitradurga. He has completed his Bachelor of Law degree at SJM College, and he has secured third rank. He has completed LLM degree from Kuvempu University. Sir has started his legal practitioner career in the chamber of Sir Fatih Rajan, that is from the year 2000 to 2009. He was selected as direct district judge in the year 2012. He served in various places such as City Civil Court Bangalore and additional district judge at Belagavi. He served as principal district judge in Udupi from 2016 to 2018. He has served as registrar, that is in administration, from 2018 to 2020. He has served as principal district judge in Bangalore Rural from 2020 to 2021. Currently, Sir is serving as Principal of Secretary to Government Law Department. We warmly welcome you, sir. Thank you.
Thank you, Madhumita. I would request Venkatesh Naik, sir, to give the inaugural address for the workshop.
Very good morning to one and all. The BMS College of Law has organized this workshop on the subject Sensitizing the Stakeholders on Food Safety and Standards Legislation. The dignitaries present on the dais, Sri K. Dwaraknath Babu, Director Kilpar, Sri Ravi Venkatesan, Trustee BMST and Chairman BMSSA, Dr. Gayatri Bai, and Srimati Priyanka, Coordinators, Dr. Revaya Vader, Research Head Kilpar, Dr. Anita F.N. D'Souza, Principal BMSL, other dignitaries who are present of the dais, my dear students and the staff of Law College, ladies and gentlemen, and members of electronic and print media. It is an immense pleasure to be with you, and I thank BMS College of Law Bangalore for inviting me as a chief guest for this program. Dear friends, national legal frameworks are a key pillar in the effective food control system. In all countries, food is governed by a complexity of laws and regulations which set out the government's requirement to be met by food chain operators to ensure food safety and quality. The term food law applies to legislation which regulates the production, trade and handling of food and hence covers the regulation of food control, food safety, quality and the relevant aspects of food trade across the entire food chain from the provision for animal feed to the consumer. The legislation that dispensed with the food safety in India was the Prevention of Food Adulteration Act 1954. Food and agriculture organizations helps governments in drafting, amending, updating national food safety and implementing regulations to strengthen the system of food control and surveillance in accordance with the international law and best practices. The Indian food processing industry is regulated by numerous laws and regulations which govern the aspects of sanitation, licensing and other essential permits that are mandatory to start up and run a food business. The legislation that dispensed with food safety in India was the Prevention of Food Adulteration Act 1954. The Prevention of Food Adulteration Act had been in place for over 5 decades and there was a need for change due to varied ins and outs which include the changing parameters of food industries. Hence, Food Safety and Standard Act 2006 came into existence. As per the Food Safety and Standard Act, the term consumer means person and families purchasing and receiving food in order to meet their personal needs. Food means any substance whether intended for human consumption. Food business, the term food business means any undertaking whether profit or not and whether public or private carrying out any of the activities related to any stage of manufacture, processing, packaging, storage, transportation, distribution of food import and includes food services, catering services, sale of food or food ingredients. The term food safety means assurance that food is acceptable for human consumption according to its intended use. Label means any tag, brand, mark, pictorial or other descriptive matter written, printed or stenciled, etc. The term standard means it relates to any article of food, means the standard notified by the food authority. The term substandard means an article of food shall be deemed to be substandard if it does not meet the specified standards but not so as to render the article of food unsafe. The term unsafe food means an article of food whose nature, substance or quality is so affected as to render it injurious to health. Every package of food shall also carry the information of the label, that is, name of the food, list of ingredients, date of manufacturing of or packing, best before and use the date, nutrition information, name and complete address of the manufacturer, net quantity, lot number, code number, batch identification number, declaration regarding veg or non-veg, declaration regarding food additives, countries of origin for import food and instruction for use. Dear friends, an effective food safety policy encompasses not only the processing itself but also the receiving and storage of raw materials. The concept of these food regulations is based on the farm to fork idea to ensure safety. During the inspection, three main types of contaminations are observed. Number one, physical, chemical and biological contaminations. Varying food safety laws are implemented as a basis for the tolerance limits of these contaminations. Physical contamination includes tangible objects such as dust, hair, fingernails, pieces of jewelry, paper or piece of metal and plastics, etc. Chemical contamination can include healthy threatening chemicals such as cleaning agents, pesticides, heavy metals and the likes. Biological microorganisms includes bacteria. So far as license is concerned, the Food Safety and Standards Licensing Regulation of Food Business Rules 2011, it governs the aspect of license and the registration of food business operator, FBO. Under regulation of the license and registration regulations, all food business operator in the country are required to be registered or licensed in accordance with the registration and licensing regulations. Hence, no person shall begin any food business unless a valid license is possessed by the food business operator, and the condition with regard to sanitary, safety and hygienic requirements have to be complied with at all times by them. One of the major purpose of this condition is to make sure that the food business operator maintain sanitary, hygienic standards as specified in each food category. It shall be the deemed responsibility of the food business operator to obey with the safety, labeling, health and sanitary requirement laid down in the license and registration regulations. So far as penalty is concerned, penalty for not having FSSAI license or registration are up to 2 lakhs. However, under section 63, it provides that if any person or food business operator who is obliged to obtain license distributes, sells, manufactures, stores or imports any article of food without license shall be punishable with imprisonment for a term which may extend to 6 months and also with fine which may extend to 5 lakhs rupees. So far as other licenses are concerned, India being a huge market, each state have their local laws and regulations which may also need to be complied with. A food operator FBO may mandatorily to get approval from the various authorities under laws. Those are health and trade license from the municipal corporation of the relevant area, registration under the shops and establishment of the respective state, environmental clearance, verification certificate under the Standard of Weightage and Measures Act 1976 for each of the outlets issued by the Department of Legal Metrology of the respective areas. Registration under the Police Act of the respective city or state. No objection certificate for fire prevention and safety. Eating house license, liquor license, a license for playing music in the restaurant is also required for playing recorded or live music. So it is mandatory for a food business to obtain insurance from any insurance company with regard to a public policy, product liability, fire policy, building and assets. Some of other registration and permissions may include registration under the Employees Provident Funds and Miscellaneous Provisions Act 1952 if it is engaging more than 20 employees. Registration is also required under the Central Excise Act as in respect of third schedule of the said act. Repacking, relabeling, putting or altering or relabeling the category of manufacture. Subject to applicability, other statutory and relabeling also include. Registrations and Income Tax Act, Custom Acts, Sale Tax, Service Tax and other laws, other labor laws. So all requirements shall be followed by the FBO. This is about food safety and standard legislation. The law college is duty bound to sensitize the stakeholders through our law students and our para-legal volunteers. So far as legal study in Karnataka is concerned, dear friends, the study of law is useful in a variety of points in view. It qualifies a man to be useful to himself, to his neighbors and to the public. These were the words of Thomas Jefferson, which indeed explain the essence of law as a discipline and a law seeker as a leader. It is not wrong to say that pursuing law is not just a career option but a life-changing experience for many. Law as a career brings out excellent leaders and passionate human beings to the world. This statement can be backed by the personalities like Mahatma Gandhiji, Barack Obama and Dr. Rajendra Prasad and many more. The question may arise as to how to study law and how to get job. Is it not? The first step in starting a career in law in India is to pursue LLB after degree and BA, BAL, LLB after a 12th class. Upon completion of the course, you can either start practicing law or join a legal firm. Another option is to prosecute LLM. What is important to note is that a career law does not necessarily mean representing clients in courts or tribunals, but it has a wider scope. Apart from tendering advice to the government agencies, business and individuals on a legal dispute and issues, law graduates can be appointed as judges, judges of civil court, judges of senior division court, judges of district courts, judges of honorable high court or high courts. You can be appointed as the litigators, consultant analyst, corporate lawyers, banking and insurance specialist law officer, public prosecutor, investigator, solicitor, lecturer in law. Dear friends, the scope of legal education in India is that law is financially lucrative career as well as intellectually challenging and earns handsome salary varying as per the role as well as the company they are working with. Another question may arise you as to how to become a lawyer. So you want to become a lawyer, or perhaps you are about to complete a law degree and are looking to map out your next steps. While being a lawyer, it takes a huge time commitment. The profession can be extremely rewarding intellectually, financially and socially, no matter where you are employed. From criminal justice litigations to environmental law, there are many fields you can delve into as a lawyer. Which one is right for you and how do you work your way up there? So, How to become a lawyer? Becoming a lawyer does not happen overnight. There are 6 critical steps you must take before you are able to become a practicing lawyer in our state. Number 1, get an undergraduate degree and you must clear bar council examination, enroll with Karnataka State Bar Council, join the office of senior advocate for better training and advice, and have a membership with any bar association in Karnataka, and you must regularly attending our courts of law, and you must study the latest law of the land. Dear friends, now you are prosecuting law. Some students may get afraid that what would be their next future. Right now, job prospectus for lawyers are very, very optimistic. The Bureau of Labor Statistics estimates an 8% job growth for lawyers over the next 10 years. The majority of lawyers work in law firms, which means private practice. In law firms, both small and large, there is usually a standard progression of job titles. So, you will take, as you work, your way up in a firm. As a law student, you may work as a summer associate or a law clerk during your breaks. You can also prepare for your career as a lawyer by working as a paralegal voluntary. Once you have a law degree, you will usually start out at a law firm as an associate. Outside the law firms, there are a variety of places where lawyer works. Many corporations retain their own legal departments, which means you would be a full-time employee of that corporation rather than a law firm. Another large area of legal practice is public interest lawyers who work for private or a non-profit organization and provide legal services to disadvantaged populations dealing with areas such as immigration and labor disputes. There are many spaces for lawyers in government positions which range from prosecutors who represent the state. Another area is standing counsel who represent parties who cannot afford their own advocate. In addition, government counsels work as lawyers in the executive and legislative branches of the government, writing and interpreting laws, writing legal reviews, and arguing civil and criminal cases for the government. The lawyer can work as corporate lawyer. The lawyer can work as a litigator. The lawyer can work as banking and insurance sector. The lawyer can work as public prosecutor. He can be a judge. He can be an investigating agency assistant. He can be a criminologist. He can be a litigation supporting professional. He can be a solicitor. He can be a legal accommodation. He can be a paralegal. Lawyer can work as a district government pleader. He can work as additional district government pleader. He can work as additional government pleader. He can work as government counsel. He can work as standing counsel. So, soon after enrolled as an advocate, you will get stipend of ₹2,000 per month for 2 years from the government side. Dear friends, if you love to engage with the challenges, problems and arguments, this way would be the right way for you because of prestige. Since ancient time, such a career has been always linked with the prestige because society pays attention to impressive appearance, high salary and legal power. Dear friends, this way would be the right way for you because of diversity. In a process of setting up of legal system, the occurrence of diversity is a sure thing. Dear friends, this way would be the right way for you because of opportunities and growth. For the last few years, meteoric changes have been taking place in the economy, social life and political institutions. Such changes have proved to expand the revenue and the profit of legal professionals. And you know what, it is just the beginning. This way would be the right way for you because of no more boredom. You will be another Sherlock Holmes. Papers, sketches, shreds of evidence, so many things will hit you up. And once you start finding patterns for the guilty ones, boredom will never touch you again. Dear friends, this would be the right way for you because of secure job. If you are working in an institution or for some sort of corporate, you won't have a chance to lose the job. Dear friends, this way would be the right way for you because of flexibility. Well, lawyers are self-governing and they have the chance to make their own schedule, set their own price and select their own clients. Dear friends, this way would be the right way for you because of awareness of rights and duties. So, once you start your career in law, you will be automatically develop an understanding of the current rights and responsibilities. Next time, no one would be able to bother you legally. Friends, while you are becoming an advocate, you must study hard. You must know all the provisions of law and the latest decision of the High Court and Supreme Court. Above all, you must follow the fundamental duties and provisions of the Advocates Act. You must be aware of the procedural laws such as Civil Procedure Code, Criminal Procedure Code, Evidence Act and other substantial laws. Above all, you must follow Advocates Swadharma. Dear friends, I think all of you read Ramayana. The ideal in our mythology is Rama, who stood by his Swadharma even when he desired to return to the palace at Ayodhya after withdrawal of boon given to Kaikeyi on the basis that Prana Jaya par Vachana Jaya. It means keep the word even at the cost of life. Though that part is tough, the future advocates and the final year law students have to adapt to it, bear out the oath of Pramana Vachana to be taken when you all entering the legal profession. I would quote another instance. Though Ravana was a king and could covet anything or anybody and get it, he went to Sita in the garb of sannyasi and did what a sannyasi should not do. Hence, Ravana had to pay a heavy price. So, our law students, when you wear the robes of advocates, you cannot but be true to it, else you meet with the fate of Ravana. Let the forthcoming advocates choose either the path of Rama, which leads to glory, or of Ravana, which ending in destruction. I may recall another instance, what Duryodhana felt when his end was about to come, that his wife Banamati may suffer at the hands of Pandavas as did Draupadi at his hands. But later realization comes to him that so long as Yudhishthira is at the helm, there will be no injustice. Similarly, even an enemy or opponent must feel that he would get justice at the hands of you young advocates, and that by itself it is too safe and safeguard. ಎಲ್ಲರಿಗೂ ಕನ್ನಡ ಬರುತ್ತಲ್ಲ? ಈ ಲೀಗಲ್ ಪ್ರೊಫೆಷನ್ ಅಂದ್ರೆ ವೆರಿ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಕಾನೂನು ವ್ಯಾಸಂಗ ಅಂದ್ರೆ ತುಂಬಾ ಆಸಕ್ತಿಕರ, ಅಷ್ಟೇ ಆಸಕ್ತಿ ಇರಬೇಕಾಗುತ್ತೆ ನಮಗೆ. ಒಂದು ಎರಡು ಸಣ್ಣ ಸ್ಟೋರಿ ಹೇಳಿ ನನ್ನ ಒಂದು ಸ್ಪೀಚನ್ನು ಮುಗಿಸ್ತೇನೆ. ಒಂದು ಋಷಿ ಕುಟೀರ ಇರ್ತದೆ. ಆ ಋಷಿ ಕುಟೀರದಲ್ಲಿ ಸುಮಾರು ಒಂದು 8 ರಿಂದ 10 ಜನ ಶಿಷ್ಯರಿರ್ತಾರೆ. ಒಬ್ಬ ಋಷಿ ಮುನಿ ಇರ್ತಾರೆ. ಆ ಋಷಿ ತನ್ನ ಶಿಷ್ಯರಿಗೆ ಒಳ್ಳೆ ವೇದ, ಉಪನಿಷತ್ತು, ಸಂಸ್ಕೃತನ ಕಲಿಸ್ತಾ ಇರ್ತಾರೆ. ಆ ಒಂದು ಋಷಿ ಮುನಿ ಕುಟೀರನ್ನ ನೋಡಿ ಒಬ್ಬ ತಾಯಿ ತನ್ನ ಮಗನಿಗೆ ಅವನಿಗೂ ಕೂಡ ಒಂದು ಒಳ್ಳೆ ವ್ಯಾಸಂಗ ಕೊಡಿಸ್ಬೇಕು ಆ ಋಷಿ ಮುನಿ ಹತ್ರ ಅಂತೇಳಿ ಕರೆದಿರ್ತಾರೆ. ಸೊ ಆ ಋಷಿ ಕೇಳ್ತಾರೆ, ಯಾರು ತಾಯಿ, ಮುನಿವರ್ಯ, ನನ್ನ ಮಗನಿಗೆ ನಿಮ್ಮ ಬಳಿ ತಾವು ಒಂದು ವ್ಯಾಸಂಗವನ್ನ ಅಂದ್ರೆ ಒಳ್ಳೆ ವಿದ್ಯಾಭ್ಯಾಸವನ್ನ ನೀಡಿ ಅಂತೇಳಿ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತಾರೆ. ಆಗ ಋಷಿಮುನಿ ತಾಯಿಗೆ ಹೇಳ್ತಾರೆ, ಆ ಸಣ್ಣ ಮಗುವಿನ ಹಸ್ತವನ್ನು ನೋಡಿ, ಇಲ್ಲಮ್ಮ, ನಿನ್ನ ಮಗನನ್ನ ನಾನು ಶಿಷ್ಯನಂತ ಸ್ವೀಕಾರ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ ಅಂತೇಳಿ. ಸೊ ಅಲ್ಲಿಗೆ ತಾಯಿಗೂ ಮತ್ತೆ ಋಷಿಗೂ ಒಂದು ವಾಗ್ವಾದ ನಡೀತದೆ. ಕೊನೆಗೆ ಆ ಋಷಿ ಕರೆದು ಹೇಳ್ತಾರೆ, ನೋಡಿ ನನ್ನ ಈ ಶಿಷ್ಯ ವೃಂದದಲ್ಲಿ ನೋಡಿ ಅವರಿಗೆಲ್ಲ ತಮ್ಮ ಹಸ್ತದಲ್ಲಿ ವಿದ್ಯಾರೇಖೆ ಇದೆ, ಆದರೆ ನಿಮ್ಮ ಮಗನ ಹಸ್ತದಲ್ಲಿ ವಿದ್ಯಾರೇಖೆ ಇಲ್ಲ ಅಂತೇಳಿ. ಆಗ ಸಣ್ಣ ಮಗು ಬೇಸರವಾಗಿ ಸ್ವಲ್ಪ ದೂರವಾಗಿ ಒಂದು ಚೂಪಾದ ಕಲ್ಲನ್ನು ತಗೊಂಡು ಕೈಯಲ್ಲಿ ಒಂದು ಈ ಥರ ಮಾರ್ಕ್ ಮಾಡಿ, ಮುನಿವರ್ಯ ಈಗಲಾದರೂ ಒಪ್ತೀರಾ ನನ್ನ ಕೈಯಲ್ಲಿ ವಿದ್ಯಾರೇಖೆ ಇದೆ ಅಂಥೇಳಿ. ಆಗ ಋಷಿ ಒಪ್ಕೊಂಡು ಅವನ ಆಸಕ್ತಿಗೆ ಮರಳಾಗಿ ಅವನಿಗೆ ಒಳ್ಳೆ ವಿದ್ಯಾಭ್ಯಾಸನ ಕೊಡ್ತಾರೆ, ಒಳ್ಳೆ ವೇದ ಉಪನಿಷತ್ತನ್ನೆಲ್ಲ ಕೊಡ್ತಾರೆ. ಅವರೇ ಪಾಣಿನಿ ಎಷ್ಟು ದೊಡ್ಡ ವಿದ್ವಾಂಸರಾದ್ರು, ಹೌದಲ್ವಾ? ಸೊ ಆ ರೀತಿ ತಾವೆಲ್ಲರೂ ಕೂಡ ಚೆನ್ನಾಗಿ ಆಸಕ್ತಿಯಿಂದ ವಿದ್ಯಾಭ್ಯಾಸ ಮಾಡಿ ನಿಮ್ಮ ಕಾಲೇಜು ಮತ್ತೆ ನಿಮ್ಮ ಮನೆಯವರು ನಿಮ್ಮ ಸಮಾಜಕ್ಕೆ ಒಳ್ಳೆ ಹೆಸರನ್ನು ತರಬೇಕು ಅಂತ ಈ ಸಂದರ್ಭದಲ್ಲಿ ಹೇಳಲಿಕ್ಕೆ ಇಷ್ಟಪಡ್ತೇನೆ. ಸೆಕೆಂಡ್ ಇನ್ಸ್ಟೆನ್ಸ್ ಏನಂದ್ರೆ, ನಮ್ಗೆ ಈ ಪ್ರೆಸೆಂಟ್ ಜನರೇಷನ್ ಅಲ್ಲಿ ನಮ್ಮ ಲೈಫ್ ತುಂಬಾ ಅಟ್ರಾಕ್ಷನ್ಸ್ ಇದೆ, ಹೌದಲ್ವಾ? ನಮ್ಗೆ ಏನೆಲ್ಲ ಇದೆ, ಲ್ಯಾಪ್ಟಾಪ್ ಇದೆ, ಸ್ಮಾರ್ಟ್ ಟಿವಿ ಇದೆ, ಆಂಡ್ರಾಯ್ಡ್ ಮೊಬೈಲ್ ಇದೆ, ಇಂಟರ್ನೆಟ್, ವಾಟ್ಸಾಪ್, ಹೌದಲ್ಲ, ಏನೆಲ್ಲ ಇದೆ. ಲೈಫ್ ಈಸ್ ಅಟ್ರಾಕ್ಷನ್ಸ್, ಅಷ್ಟೇ ಡೇಂಜರ್ ಇದೆ. ಇದಕ್ಕೆ ಒಂದು ಉದಾಹರಣೆ ಏನಂದ್ರೆ, ಒಂದು ರಾತ್ರಿಯಲ್ಲಿ ಅಂದ್ರೆ ತುಂಬಾ ಕತ್ಲಿರ್ತದೆ, ಆ ಕತ್ಲಲ್ಲಿ ಒಂದು ದೀಪ ಉರಿತಾ ಇರ್ತದೆ. ಆ ದೀಪದ ಅಟ್ರಾಕ್ಷನ್ಗೆ ಚಿಟ್ಟೆಗಳು ಅದರ ಹತ್ರ ಹೋಗ್ತದೆ, ಅದರ ಒಂದು ರೆಕ್ಕೆ ಪುಕ್ಕುಗಳೆಲ್ಲ ಸುಟ್ಟೋಗ್ತದೆ. ಆದರೆ ಪ್ರತಿ ಚಿಟ್ಟೆಗಳು ಆ ದೀಪದ ಅಟ್ರಾಕ್ಷನ್ಸ್ಗೆ ಬರ್ತದೆ, ಎಲ್ಲ ತನ್ನ ರೆಕ್ಕೆ ಪುಕ್ಕೆ ಎಲ್ಲ ಸುಟ್ಟು ಅಲ್ಲೇ ಸತ್ತು ಹೋಗ್ತದೆ. ಬಟ್ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಲ್ಲ ಇದು ಅಟ್ರಾಕ್ಷನ್ಸ್ ನಾವು ಎಲ್ಲ ಸುಟ್ಟು ಹೋಗ್ತೀವಿ ಅನ್ನೋದು. ಸೊ ನಮ್ಮ ಲೈಫ್ ಕೂಡ ಅಷ್ಟೇನೆ, ನಾವು ಅಟ್ರಾಕ್ಷನ್ಸ್ ಅಂತ ಹೋದ್ರೆ ನಾವು ಕೂಡ ಎಲ್ಲ ಕಳ್ಕೋಬೇಕಾಗತ್ತೆ. ಸೊ ಪ್ಲೀಸ್ ಅವೇರ್ ಆಫ್ ದಿಸ್ ಅಟ್ರಾಕ್ಷನ್ಸು ತುಂಬಾ ನೋಡ್ಲಿಕ್ಕೆ ಅಷ್ಟೇ ಸುಂದರ, ಅನುಭವಿಸಿದ್ರೆ ಆಪತ್ತಿಗೆ ಆಹ್ವಾನ ಮಾಡ್ಕೋತೀರಿ. ತಾವೆಲ್ಲರೂ ಕೂಡ ಹ್ಯೂಮನ್ ಬೀಯಿಂಗ್ಸ್, ವಿ ಬೀಯಿಂಗ್ ದಿ human beings, we have to follow and we must maintain human duties. ಮಾನವ ಗುಣಗಳನ್ನ ನಾವೆಲ್ಲರೂ ಕಾಪಾಡಬೇಕು. ಒಬ್ಬ ಸಾಧು ನದಿ ದಂಡೆಯಲ್ಲಿ ಧ್ಯಾನ ಮಾಡ್ತಾ ಇರ್ತಾನೆ. ಆ ರೀತಿ ಧ್ಯಾನ ಮಾಡುವಾಗ ತನ್ನ ಒಂದು ತೊಡೆಗೆ ಒಂದು ಚೇಳು ಕಸ್ತಾ ಇರ್ತದೆ. ಅಲ್ಲಿ ಒಬ್ಬ ವ್ಯಕ್ತಿ ದಾರಿ ನಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇರ್ತಾನೆ. ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಗುರುವರ್ಯ ನಿಮ್ಮ ತೊಡೆಗೆ ಒಂದು ಚೇಳು ಕಸ್ತಾ ಇದೆ, ಅದನ್ನ ಅಲ್ಲೇ ಹೊಸ್ಕಾಕಿ, ಅದು ವಿಷಜಂತು ಅಂತ ಹೇಳಿ. ಆಗ ಈ ಗುರುವರೇ ಹೇಳ್ತಾರೆ, ಸ್ವಾಮಿ ನೋಡಿ, ಅದು ಒಂದು ಚೇಳು ವಿಷಜಂತು, ತನ್ನ ಕರ್ತವ್ಯನು ಕಚ್ಚಿ ತನ್ನ ವಿಷವನ್ನು ಬಿಡುವಂಥದ್ದು. ಒಂದು ವಿಷಜಂತು ತನ್ನ ಕರ್ತವ್ಯನ ಮರ್ತಾ ಇಲ್ಲ. ಮಾನವರಾದ ನಾವು ಪ್ರಾಣ ರಕ್ಷಣೆ ಕೊಡೋದು ನಮ್ಮ ಕರ್ತವ್ಯ ಅಂತ ಹೇಳಿ ಅದನ್ನೊಂದು ರಕ್ಷಣೆ ಮಾಡಿ ಅದನ್ನ ಪಕ್ಕಕ್ಕೆ ಸರಿಸಿ ಮುಂದೆ ಹೋಗ್ತಾರೆ. ಸೊ ನಾವೆಲ್ಲರೂ ಕೂಡ ಮಾನವ ಜೀವಿಗಳು, ಪ್ರಾಣ ರಕ್ಷಣೆ ಕೊಡೋದೆಲ್ಲ ನಮ್ಮ ಕರ್ತವ್ಯ. ಹಾಗಾಗಿ ತಾವೆಲ್ಲರೂ ಕೂಡ ಒಳ್ಳೆಯ ಮಾನವರಾಗಿ ಇರಿ ಅಂತ ಹೇಳ್ತಾ, ನಾನು ಈ ದಿನ ತಮ್ಮ ಕಾಲೇಜಿಗೆ ಭೇಟಿ ನೀಡಿದಾಗ ತಮ್ಮ ಪ್ರಾಂಶುಪಾಲರು ನಿಮ್ಮ ಲೈಬ್ರರಿ ಈ ಲೈಬ್ರರಿ ಎಲ್ಲವನ್ನ ತೋರಿಸಿದ್ರು. ನಮಗೆ ನೋಡಿ ತುಂಬಾ ಖುಷಿ ಆಯಿತು. ಈವನ್ ದೊಡ್ಡ ಕೋರ್ಟ್ಸ್, ದೊಡ್ಡ ಲಾ ಕಾಲೇಜುಗಳಲ್ಲೇ ಅಷ್ಟೊಂದು ಒಳ್ಳೆ ಫೆಸಿಲಿಟೀಸ್ ಇಲ್ಲ. ತಮಗೆ ಒಳ್ಳೆ ಲೈಬ್ರರಿ ಇದೆ, ಲೈಬ್ರರಿ ಇದೆ. ತಾವು ಏನ್ ಬೇಕಾದರೂ ಓದ್ಬೋದು, ಅಲ್ಲಿ ನಾಲೆಡ್ಜ್ ಅನ್ನ ಗೇನ್ ಮಾಡ್ಕೋಬಹುದು. ಫಿಂಗರ್ ಟಿಪ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲಾ ಮಾಹಿತಿಗಳು ಸಿಗ್ತದೆ. ಪ್ಲೀಸ್ ಡೋಂಟ್ ವೇಸ್ಟ್ ಯುವರ್ ಟೈಮ್. ಈ ಟೈಮು ಮತ್ತೆ ಸಿಗೋದಿಲ್ಲ. ಒಂದ್ಸಲ ವಾಟ್ಸಪ್ಗೆ ಹೋದ್ರೆ ½ ಬೇಕು ಹೊರಗಡೆ ಬರಲಿಕ್ಕೆ. ತಾವು ಒಂದ್ಸಲ ಇಂಟರ್ನೆಟ್ ಸರ್ಫಿಂಗ್ ಮಾಡಿದ್ರೆ ½ ಬೇಕು, ಹೌದಲ್ಲ? ಈಗೇನೋ ಅದು ಮೊಬೈಲಲ್ಲಿ ಮೂವ್ಸ್ ಮತ್ತೆ ಯಾವ್ದದು ಟ್ವಿಟರ್, ನೀವು ಅದೆಲ್ಲ ನೋಡ್ತಾ ಇದ್ರೆ ವಾಪಸ್ ಬರ್ಲಿಕ್ಕೆ ಒನ್ ಅವರ್ ಬೇಕು. ಸೊ ಡೋಂಟ್ ವೇಸ್ಟ್ ಯುವರ್ ಟೈಮ್. ನಿಮ್ಮ ಮೊಬೈಲ್, ನಿಮ್ಮ ಲ್ಯಾಪ್ಟಾಪ್ ಏನೇ ಇದ್ರೂ ಕೂಡ ಫಾರ್ ಗೇನಿಂಗ್ ನಾಲೆಡ್ಜ್. ನಮ್ಮ ಮೊಬೈಲು ಕೂಡ ಇದೆ ಓನ್ಲಿ ಫಾರ್ ಡಿಸಿಷನ್ಸ್, ಆಕ್ಟ್ಸ್, ಲೇಟೆಸ್ಟ್ ಏನು ನಾಲೆಡ್ಜ್ ಏನಿದೆಯೋ, ಜನರಲ್ ನಾಲೆಡ್ಜ್, ಅದಕ್ಕೆ ಮಾತ್ರ ನಾವು ಉಪಯೋಗಿಸ್ತೇವೆ. ಅದೇ ರೀತಿ ತಮ್ಮ ಡ್ರೆಸ್ ಕೋಡ್ ನೋಡಿ ನನಗೆ ಇಷ್ಟ ಆಯಿತು. ಎಲ್ಲರೂ ಬ್ಲಾಕ್ ಕೋಟ್ ಹಾಕಿದ್ದೀರಾ, ಇಟ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಅದೇ ರೀತಿ ತಾವೆಲ್ಲರೂ ಲಾ ಡಿಗ್ರಿ ಮುಗಿಸಿ ಎನ್ರೋಲ್ಮೆಂಟ್ ಆಗಿ ಪ್ರಾಕ್ಟೀಸ್ ಹೋಗುವಾಗ ಎಲ್ಲರೂ ಸ್ಮಾರ್ಟ್ ಆಗಿರ್ಬೇಕು. ಈ ರೀತಿ ಗಡ್ಡ ಬಿಡಬಾರ್ದು. ವಕೀಲರು ಯಾರಾದ್ರೂ ಗಡ್ಡ ಬಿಟ್ಟಿದ್ದನ್ನು ನೋಡಿದ್ದೀರಾ? ಪ್ಲೀಸ್ ರಿಮೂವ್ ಇಟ್. ಬಿ ಸ್ಮಾರ್ಟ್. ವೈಟ್ ಅಂಡ್ ವೈಟ್ ಅಲ್ಲಿ ಬರಬೇಕು. ಕಟಿಂಗ್ ಮಾಡಿಸ್ಕೊಂಡು ಕ್ಲೀನಾಗಿ ಚೆನ್ನಾಗಿರ್ಬೇಕು. ಯಾಕಂದ್ರೆ ವೈಟ್ ಅಂಡ್ ವೈಟ್ ಹಾಕಿ ಡಿಸಿಪ್ಲಿನ್ ಮೇಂಟೈನ್ ಮಾಡಬೇಕು. ಸೊ ಈ ಹಂತದಲ್ಲಿ ನನ್ನನ್ನು ಕರೆಸಿ 2 ಮಾತಾಡಲಿಕ್ಕೆ ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟ ತಮ್ಮ ಸಂಸ್ಥೆಗೆ ಧನ್ಯವಾದಗಳು. ಜೈ ಹಿಂದ್, ಜೈ ಕರ್ನಾಟಕ ಮಾತೆ.
Thank you, sir, for the informative talk. Now I request Mahalingaya from 6th semester BCom LLB to introduce K. Dwarkanath Babu, sir, Director, Kilper.
Thank you, Sneha. Sir K. Dwarkanath Babu graduated with a BCom degree from RC College of Commerce, Bangalore in the year 1978 and did LLB from Vivipuram College of Law in 1984 and MA in Kannada from Bangalore University in the year 1987. Sir joined government service in the year 1983 and served for more than 38 years. Sir served as Special Secretary to the Government Department of Parliamentary Affairs and Legislation from the year 2013 to 2016. Sir served as Secretary to the Government Department of Parliamentary Affairs and Legislation and was a member syndicate and a member of the Academic Council for Karnataka Law University, Hubli, as well as member of the Karnataka Institute for Law and Parliamentary Affairs from 2016 to 2021. Sir worked as Secretary, Scrutinizing Committee under the chairmanship of Honorable Law Minister for more than 10 years. Sir worked as an advisor to a Committee on Subordinate Legislation of State Legislature for more than 10 years and drafted major legislations. Sir is currently serving as Director, Karnataka Institute for Law and Parliamentary Reform from August 2021. Sir, we are privileged to have you here.
Thank you, Mahalingaya. I would request K. Dwarkanath Babu, sir, to address the gathering.
Good morning, everybody. ಇವತ್ತಿನ ದಿನ ಕರ್ನಾಟಕ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಫ್ ಲಾ ಅಂಡ್ ಪಾರ್ಲಿಮೆಂಟರಿ ರಿಫಾರ್ಮ್ಸ್ ಹಾಗೂ BMS ಕಾಲೇಜ್ ವತಿಯಿಂದ ಸೆನ್ಸಿಟೈಸಿಂಗ್ ದಿ ಸ್ಟೇಕ್ ಹೋಲ್ಡರ್ಸ್ ಆ್ಯಂಡ್ ಫುಡ್ ಸೇಫ್ಟಿ ಆ್ಯಂಡ್ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಲೆಜಿಸ್ಲೇಷನ್ ಇದ್ರ ಬಗ್ಗೆ ಒಂದು ವರ್ಕ್ಶಾಪ್ ನಡೆಸಬೇಕು ಅನ್ನೋ ಉದ್ದೇಶದಿಂದ ಈ ಕಾರ್ಯಕ್ರಮ ಹಮ್ಮಿಕೊಂಡಿದ್ದೀವಿ. ಇದರಲ್ಲಿ ಪಾಲ್ಗೊಳ್ಳೋಕ್ಕೆ ವಿವಿಧ ಕಾಲೇಜಿಂದ ಬಂದಿದ್ದೀರಾ ಅಂತ ಅಂದ್ಕೊಂಡಿದ್ದೀನಿ. ಸೊ ಈ ವರ್ಕ್ಶಾಪ್ ನಡೆಸೋ ಉದ್ದೇಶ ಏನು, ಯಾತಕ್ಕಾಗಿ ಈ ವರ್ಕ್ಶಾಪ್ ನಡೆಸಬೇಕು? ಫುಡ್ ಸೇಫ್ಟಿ ಆ್ಯಂಡ್ ಸ್ಟ್ಯಾಂಡರ್ಡ್ಸ್ ಆ್ಯಕ್ಟ್ 2006 ಇದು ಒಂದು ಪಾರ್ಲಿಮೆಂಟ್ ಲೆಜಿಸ್ಲೇಷನ್, ಸೆಂಟ್ರಲ್ ಗೌರ್ಮೆಂಟ್ ಮಾಡಿರುವಂಥ ಒಂದು ಲೆಜಿಸ್ಲೇಷನ್. ಈ ಮೊದಲು ಫುಡ್ ಅಡಲ್ಟ್ರೇಷನ್ ಆ್ಯಕ್ಟ್ ಅಂತ ಇತ್ತು, 1954 ಆ್ಯಕ್ಟು. ಅದು ಬಹಳಷ್ಟು ಬದಲಾವಣೆಗಳಾಗಬೇಕಾದ್ದರಿಂದ ಅದನ್ನು ರಿಪೀಲ್ ಮಾಡಿ ಈ ಹೊಸ ಲೆಜಿಸ್ಲೇಷನ್ 2006 ತಂದರು. ಇದರಲ್ಲಿ ತಮಗೆಲ್ಲ ತಾವು ಈ ವರ್ಕ್ಶಾಪ್ ಬರೋ ಮುಂಚೆ ಅದನ್ನು ಓದಿದ್ದೀರಾ ಅಂತ ನಾವು ಭಾವಿಸ್ಕೋಬೇಕಾಗುತ್ತೆ. ನೀವು ಓದ್ಕೊಂಡು ಬಂದರೆ ಇಫ್ ಯು ಕಮ್ ವಿತ್ ಲಿಟಲ್ ಪ್ರಿಪ್ರೇಷನ್ ಯು ವಿಲ್ ಹ್ಯಾವ್ ಸರ್ಟನ್ ಡೌಟ್ಸ್ ಇನ್ ಯುವರ್ ಮೈಂಡ್. ಏನು ಇದರಲ್ಲಿ ಏನು ಹೊಸದಿದೆ, ಯಾತಕ್ಕೆ ಹೊಸ ಲೆಜಿಸ್ಲೇಷನ್ ತಂದರು, ಹಳೇದೇನಾಗಿತ್ತು. ಇದರ ಶೆಡ್ಯೂಲ್ 2ನಲ್ಲಿ ತಾವೆಲ್ಲ ನೋಡಿದರೆ ಯಾವ್ಯಾವುದನ್ನ ರಿಪೀಲ್ ಮಾಡಿದ್ದಾರೆ ಈ ಹೊಸ ಲೆಜಿಸ್ಲೇಷನ್ ತರುವಾಗ ಅಂತ ಯು ಕ್ಯಾನ್ ಸಿ ಇನ್ ದಿ ಶೆಡ್ಯೂಲ್ ಟು ದಿ ಆ್ಯಕ್ಟ್. ಶೆಡ್ಯೂಲ್ 2 ನೋಡಿದರೆ ಗೊತ್ತಾಗುತ್ತೆ. ಅದರಲ್ಲಿ ದೇರ್ ಇಸ್ ಎ ಲಿಸ್ಟ್ ಆಫ್ ಒನ್ ದಿಸ್ ಫುಡ್ ಅಡಲ್ಟ್ರೇಷನ್ ಆ್ಯಕ್ಟ್ ಆ್ಯಂಡ್ ಸರ್ಟನ್ ಆರ್ಡರ್ಸ್. ದೋಸ್ ಆರ್ಡರ್ಸ್ ವರ್ ಮೇಡ್ ಅಂಡರ್ ಎಸೆನ್ಷಿಯಲ್ ಕಮಾಡಿಟಿ ಆ್ಯಕ್ಟ್. ಕಂಟ್ರೋಲ್ ಆರ್ಡರ್ಸ್, ಫುಡ್ ಕಂಟ್ರೋಲ್ ಆರ್ಡರ್ಸ್, ಈ ರೀತಿ ಕೆಲವನ್ನೆಲ್ಲ ರಿಪೀಲ್ ಮಾಡಿ ಈ ಶಾಸನ ತಂದರು. ಇದರಲ್ಲಿ ಮುಖ್ಯವಾಗಿ ಫುಡ್ ಅಥಾರಿಟಿ ಅಂತ ಒಂದು ಬಾಡಿ ಕ್ರಿಯೇಟ್ ಮಾಡಿದರು. ಇದಕ್ಕೆ ಅಡ್ವೈಸ್ ಮಾಡುವಂಥ ಒಂದು ಸೈಂಟಿಫಿಕ್ ಪ್ಯಾನಲ್ ಮತ್ತು ಸೈಂಟಿಫಿಕ್ ಆಫೀಸರ್ಸ್ದು ಒಂದು ಫೋರಮ್, ಇವನ್ನೆಲ್ಲ ಕ್ರಿಯೇಟ್ ಮಾಡಿದರು. ಪ್ಯಾಕ್ಡ್ ಫುಡ್ಸ್, ಇದಕ್ಕೆ ಯಾವ್ಯಾವ ನಾರ್ಮ್ಸ್ ಇರಬೇಕು, ಅಡಲ್ಟ್ರೇಷನ್ ತಡೆಯೋದು ಹೇಗೆ, ಅಡಲ್ಟ್ರೇಷನ್ ತಡೆಯೋಕ್ಕೆ ಮೊದಲು ಇತ್ತು ಕಾನೂನು, ಆದರೆ ಇತ್ತೀಚೆಗೆ ಆದ ಬೆಳವಣಿಗೆಗಳನ್ನ ಅದರಲ್ಲಿ ಅಳವಡಿಸೋಕ್ಕಾಗಿರಲಿಲ್ಲ. ಮತ್ತು ಯಾವ ರೀತಿ ಸರ್ಕಾರಕ್ಕೆ ಅಡ್ವೈಸ್ ಮಾಡಬೇಕು, ಅಡ್ವೈಸರಿ ಬಾಡಿಯಾಗಿ ಫುಡ್ ಅಥಾರಿಟಿ, ಕೆಲವು ರೆಗ್ಯುಲೇಟರಿ ಬಾಡಿ ಕೂಡ, ಮತ್ತು ಅದಕ್ಕೆ ಅಡ್ವೈಸರಿ ಬಾಡಿ ಕೂಡ ಕ್ರಿಯೇಟ್ ಮಾಡಿದರು. This will advise day-to-day modifications required in the regulation. ಯಾವ ರೀತಿ ಫುಡ್ ಸ್ಟ್ಯಾಂಡರ್ಡ್ಸ್ನ ದಿನ ದಿನಕ್ಕೆ ಬದಲಾಗ್ತಾ ಹೋಗುತ್ತೆ. ಇವತ್ತಿದ್ದಿದ್ದು ನಾಳೆ ಇರೋಲ್ಲ. ಯಾವುದೇ ಫುಡ್ ಪ್ರಾಡಕ್ಟ್ಸ್ ಇರ್ಬೋದು, ತಾವು ನೋಡಿದಾಗೆ ಮೊದಲಿದ್ದಕ್ಕೂ ಈಗೂ ಇದರಲ್ಲಿ ವೆಜಿಟೇರಿಯನ್, ನಾನ್ ವೆಜಿಟೇರಿಯನ್, ಮಿಲ್ಕ್ ಪ್ರಾಡಕ್ಟ್ಸ್, ಎಲ್ಲ ರೀತಿಯ ಫುಡ್ಡನ್ನು ರೆಗ್ಯುಲೇಟ್ ಮಾಡುವಂಥ ರೆಗ್ಯುಲೇಷನ್ಸನ್ನು ಕೂಡ ಇದರಲ್ಲಿ ಮಾಡುವಂಥ ಸಬಾರ್ಡಿನೇಟ್ ಲೆಜಿಸ್ಲೇಷನ್ಸ್ ಇವೆ ಇದರಡಿಯಲ್ಲಿ. ಈ ರೀತಿ ಮಾಡಿದಾಗ ರಾಜ್ಯ ಮಟ್ಟದಲ್ಲಿ ಫುಡ್ ಸೇಫ್ಟಿ ಕಮಿಷನರ್ನ ಮಾಡಿದರು, ಜಿಲ್ಲಾ ಮಟ್ಟದಲ್ಲಿ ಡೆಸಿಗ್ನೇಟೆಡ್ ಆಫೀಸರ್ ಅಂತ ಮಾಡಿದರು, ಹೂ ಕ್ಯಾನ್ ಗಿವ್ ಲೈಸೆನ್ಸ್ ಟು ದಿ ಫುಡ್ ಆಪರೇಟರ್ಸ್. ಇದಲ್ದಿರ ಫುಡ್ ಸೇಫ್ಟಿ ಆಫೀಸರ್ಸ್ ನೇಮಕ ಮಾಡೋಕ್ಕೆ ಒಂದು ಪ್ರೊವಿಷನ್ ಮಾಡಿದರು, ಹೂ ಕ್ಯಾನ್ ಇನ್ಸ್ಪೆಕ್ಟ್, ಸರ್ಚ್ ಅಂಡ್ ಸೀಸ್, ಯು ಕ್ಯಾನ್ ಟೇಕ್ ಸ್ಯಾಂಪಲ್ಸ್ ಆಫ್ ದಿ ಫುಡ್. ಇವನ್ನೆಲ್ಲ ತಗೊಂಡು ಲ್ಯಾಬೊರೇಟರಿಗೆ ಕಳಿಸಿ ಸಬ್ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಇದ್ದಲ್ಲಿ ಅವ್ರ ಮೇಲೆ ಕಾನೂನು ಕ್ರಮ ತಗೋಬೇಕಾದಂಥ ಜವಾಬ್ದಾರಿ ಫುಡ್ ಸೇಫ್ಟಿ ಆಫೀಸರ್ ಮೇಲೆ ಇರುತ್ತೆ. ಈ ಒಂದು ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್, ಈ ಮೆಷಿನರಿನ ಈ ಹೊಸ ಕಾನೂನಲ್ಲಿ ಡೀಟೇಲ್ ಆಗಿ ಅವರ ಜವಾಬ್ದಾರಿಗಳೇನು, ಅವರ ಕರ್ತವ್ಯ ಏನು, ಎಲ್ಲಿ ಇವರನ್ನ ಕಾನೂನುಬದ್ಧವಾಗಿ ನ್ಯಾಯಾಲಯ ಕಡೆ ಹಂತವಾಗಿಟ್ಟರು. ಈ ಆಕ್ಟ್ ನೀವು ಓದಿದರೆ ದಿ ಲಾಸ್ಟ್ ಪ್ರಿಫರೆನ್ಸ್ ಇಸ್ ಕೋರ್ಟ್. ಮೊದಲು ಆಫೀಸರ್ ಲೆವೆಲಲ್ಲಿ, ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಲೆವೆಲಲ್ಲಿ ಇದನ್ನು ಇತ್ಯರ್ಥ ಮಾಡೋದಕ್ಕೆ, ಅಲ್ಲಿಂದ ಅಪೀಲು ಟ್ರಿಬ್ಯುನಲ್ಗೆ 2 ಹಂತ ಇಟ್ಟರು. ಟ್ರಿಬ್ಯುನಲ್ನಲ್ಲಿ ಆಗಿಲ್ಲ ಅಂದರೆ ಕೆಲವು ಕೋರ್ಟ್ಗೆ ಹೋಗೋ ರೀತಿ, though it is a cognizable offence, court should not take cognizance unless there is a written complaint by the food safety officer. ಈ ಥರ ಎಲ್ಲ ಒಂದು ಪ್ರೊಸೀಜರ್ ತಂದರು. ಹೆಚ್ಚಾಗಿ ಇದರಲ್ಲಿ ತಾವು ನೋಡಿದಾಗೆ ಇಟ್ ಈಸ್ ಎ ರೆಗ್ಯುಲೇಟರಿ ಲೆಜಿಸ್ಲೇಷನ್, ಇಟ್ಸ್ ನಾಟ್ ಎ ಪೀನಲ್ ಲೆಜಿಸ್ಲೇಷನ್. And the main feature is, see, if you go through the penal classes, ಈ ಪೆಕ್ಯುನರಿ ಇದು ಏನು ಬರೀ ದಂಡ ಹಾಕುವಂಥ ಪ್ರೊವಿಷನ್ಸೇ ಜಾಸ್ತಿ ಇಟ್ಟಿದ್ದಾರೆ. ಜೈಲಿಗೆ ಹಾಕುವಂಥದ್ದು, ಇಂಪ್ರಿಸನ್ಮೆಂಟು ಕಡಿಮೆ ಪ್ರೊವಿಷನ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ಈ ಹೊಸ ಒಂದು ರಿನೋವೇಟಿವ್, ಇಟ್ ಈಸ್ ಎ ನ್ಯೂ ಲಾ 2006 ಈ ರೀತಿ ರೆಗ್ಯುಲೇಟರಿ ಲಾ ಅನ್ನೋದು ಒಂದು ಕೆಟಗರಿ. ನೀವು ಯಾವುದೇ ಲಾ ಒಳಗೆ ರೆಗ್ಯುಲೇಟರಿ ಲಾ ಈಸ್ ಓನ್ಲಿ ಟು ರೆಗ್ಯುಲೇಟ್ ಆಸ್ ಎ ಮಾನಿಟರ್. ಸರ್ಕಾರ ರೆಗ್ಯುಲೇಟ್ ಮಾಡಲಿಕ್ಕಾಗಿ ಮಾಡಿದಂಥದ್ದು. ಎಲ್ಲದಕ್ಕೂ ಜೈಲು ಶಿಕ್ಷೆ ವಿಧಿಸೋದು ಸರ್ಕಾರದ ಉದ್ದೇಶ ಅಲ್ಲ. ತಪ್ಪು ಮಾಡಿದವ್ರನ್ನ ಸರಿ ದಾರಿ ತರಬೇಕಾದ್ರೆ ಯಾವ ರೀತಿ ಮಾಡಬೇಕು, ಅವರಿಗೆ ದಂಡ ವಿಧಿಸಿ ಅವ್ರನ್ನ, ಆ್ಯಂಡ್ ವೆನ್ ಎವರ್ ಸಚ್ penalties are levied, there is a provision to recover as arrears of land revenue from such defaulters. ಈ ರೀತಿ ಎಲ್ಲ ಪ್ರೊವಿಷನ್ ಮಾಡಿದ್ದಾರೆ. ಇದರ ಅವೇರ್ನೆಸ್ ಆಸ್ ಎ ಲಾ ಸ್ಟೂಡೆಂಟ್ಸ್ ತಮಗೆ ಬೇಸಿಕ್ ಈಗಲಿಂದ ನೀವು ತಿಳ್ಕೋಬೇಕು. ಸಮಾಜದಲ್ಲಿ ಫುಡ್ ಅಡಲ್ಟ್ರೇಷನ್ ಈಸ್ ನಾಟ್ ಎ ನ್ಯೂ ಅಫೆನ್ಸ್. ಭಾಳ ಹಿಂದಿನಿಂದ ನಡ್ಕೊಂಡು ಬಂದಂಥದ್ದು. ಆದರೆ ಅದನ್ನು ತಡೆಯುವಂಥ ಪ್ರಯತ್ನ ಎಲ್ಲರೂ ಮಾಡಬೇಕಾದ ಕರ್ತವ್ಯ. ಆ್ಯಸ್ ಎ ಲೀಗಲ್ ಸ್ಟೂಡೆಂಟ್ಸ್ ಅಥವಾ ಲಾ ಓದುವಂಥ ಯಾವ ರೀತಿ ಇಂಥ ಅಫೆನ್ಸ್ಗಳನ್ನ ತಡೆಯೋಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡಬೇಕು. ನಾವಿನ್ನೂ ಸ್ಟೂಡೆಂಟ್ಸು, ನಾವೇನು ಮಾಡೋದು, ನಾವು ಲಾಯರ್ ಆದಾಗ ನೋಡ್ಕೊಂಬೋಣ ಅಲ್ಲ. ಈಗಲಿಂದ ನೀವು ಕಾನೂನು ಓದೋದು, ಕಾನೂನು ಹೇಗೆ ಇಂಪ್ಲಿಮೆಂಟ್ ಆಗುತ್ತೆ, ಅದನ್ನು ಯಾವ ರೀತಿ ನೀವು ಇದರಿಂದ ತೊಂದರೆ ಒಳಗಾದವ್ರಿಗೆ ಯಾವ ರೀತಿ ಸಹಾಯ ಮಾಡ್ಬೋದು ಆ್ಯಸ್ ಎ ಲಾ ಸ್ಟೂಡೆಂಟ್. ತಾವು ನೋಡಿದ್ದೀರಾ ಎಷ್ಟೋ ಸತಿ ಕೊಕ್ಕೋ ಕೋಲಾದಲ್ಲಿ ಪೆಸ್ಟಿಸೈಡ್ಸ್ ಇದೆ ಅಂತ ಬರುತ್ತೆ. ಅದರಲ್ಲಿ ಯಾವುದೋ ಒಂದು ಎಣ್ಣೆ ಒಳಗಡೆ ಇಲಿ ಇತ್ತು. ಈ ಥರ ಎಲ್ಲ ನೀವು ದಿನ ಒಂದೊಂದು ಪೇಪರಲ್ಲಿ ಓದ್ತೀರಾ. ಸೊ ಅದಕ್ಕೆ ಒಂದು ಎಡಿಬಲ್ ಆಯಿಲ್ ಆಗ್ಬೋದು ಅಥವಾ ಒಂದು ಫುಡ್ ಆಗ್ಬೋದು, ಅದರ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಕಳ್ಕೊಂಡು ಆರೋಗ್ಯಕ್ಕೆ ಬಾಧಕ ಆಗೋ ಥರ ಫುಡ್ ಪಾಯ್ಸನಿಂಗ್ ಆಗಿರ್ಬೋದು, ಇನ್ನೊಂದು ಆಗಿರ್ಬೋದು. ಈಗ ಚಾಕ್ಲೇಟ್ಸಲ್ಲಿ ಹುಳ ಇತ್ತು ಅಂತ ಕೂಡ ತಾವು ನೋಡಿದ್ದೀರ. ಇವನ್ನೆಲ್ಲ ತಡೆಯೋ ಅಂಥದ್ದು ಎಲ್ಲರ ಕರ್ತವ್ಯ, ಪ್ರತಿಯೊಬ್ಬ ಸಿಟಿಸನ್ ಕರ್ತವ್ಯ, ಎಸ್ಪೆಷಲಿ law students, because you are in the field of law. You can understand provisions very faster than any other layman. So ಹಾಗಾಗಿ ನೀವು ಈ ಪ್ರೊವಿಷನ್ಸ್ನ ಈಗಲಿಂದ ಕರಗತ ಮಾಡಿಕೊಂಡು ಸಮಾಜಕ್ಕೆ ನೀವು ಹೆಲ್ಪ್ಫುಲ್ ಹ್ಯಾಂಡ್ಸ್ ಆಗಿ ನಿಲ್ಲಬೇಕು. ಅದೇ ನಮ್ಮ ಉದ್ದೇಶ. ಇಟ್ ಈಸ್ ಎನ್ ಅವೇರ್ನೆಸ್ ಪ್ರೋಗ್ರಾಮ್. ಈ ವರ್ಕ್ಶಾಪ್ ಮೂಲಕ ತಾವೆಲ್ಲ ಇದನ್ನು ಓದಿ, ಆಕ್ಟಿನ ಓದಿ ಯಾವ ರೀತಿ ನೀವು ಸಾರ್ವಜನಿಕರಿಗೆ ಸಹಾಯ ಹಸ್ತ ಚಾಚಬಹುದು, ಅವ್ರನ್ನ ಯಾವ ರೀತಿ ಇದಂಥ ಒಂದು ಡಿಫಾಲ್ಟರ್ಸ್ ಏನಿದ್ದಾರೆ, ಈ ಫುಡ್ ಅಡಲ್ಟ್ರ್ ಮಾಡೋರು. ಈಗ ತಾವು ನೋಡಿದಂಗೆ ಮೊದಲು ಏನು ಅಕ್ಕಿಯಲ್ಲಿ ಕಲ್ಲುಗಳು ಬರ್ತಿತ್ತು, ಅದು ಒಂದು ಕಾಲ. ಈಗೆಲ್ಲ ಅದು ಕಡಿಮೆ ಆಗಿದೆ. ಆದರೆ ಪ್ಲಾಸ್ಟಿಕ್ ಅಕ್ಕಿ ಬರುತ್ತೆ ಅನ್ನೋ ಒಂದು ಕೇಳಿದ್ದೀರಾ? ಅಕ್ಕಿಯಲ್ಲಿ ಪ್ಲಾಸ್ಟಿಕ್ದು ಸೇಮ್ ಮಾಡೆಲ್ ಮಾಡಿ ಸೇರಿಸ್ಬಿಡ್ತಾರೆ. ಈ ಥರನೂ ನಡೀತಾ ಇದೆ. ಸೊ ಇಂಥವನ್ನೆಲ್ಲ ತಡೆಯೋ ಜವಾಬ್ದಾರಿ ನಿಮಗೂ ಇದೆ, ಹೆಚ್ಚಾಗಿ ನಿಮಗಿದೆ. ಬೇರೆ ಸಾಮಾನ್ಯ ಜನಕ್ಕಿದ್ದಕ್ಕಿಂತ ಕಾನೂನು ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಹೆಚ್ಚಾಗಿದೆ. ಹಾಗಾಗಿ ಈ ಅವೇರ್ನೆಸ್ ಪ್ರೋಗ್ರಾಮ್ ಮೂಲಕ ಈ ಕಾರ್ಯಕ್ರಮ ಹಮ್ಮಿಕೊಂಡಿದ್ದೀವಿ. ತಾವೆಲ್ಲ ಇದರಲ್ಲಿ ಹೆಚ್ಚು ಸಂಖ್ಯೆಯಲ್ಲಿ ಪಾಲ್ಗೊಂಡಿದ್ದೀರಾ. ಇದು ಕೇಳಿ ಯು ಇಂಪ್ರೂವ್ ಯುವರ್ ನಾಲೆಡ್ಜ್ ಆ್ಯಂಡ್ ಎಕ್ಸ್ಟೆಂಡ್ ಯುವರ್ ಹೆಲ್ಪ್ ಟು ದಿ ಸೊಸೈಟಿ. ಥ್ಯಾಂಕ್ ಯು.
Thank you, sir. It was a pleasure listening to you. Now I would request Principal Ma'am Anita F.N. D'Souza to give the presidential address.
Good morning and warm welcome to one and all present here. At the outset, I would like to express my heartfelt gratitude to Shri Venkatesh Naik, Principal Secretary, Law Department, Shri Dwaraknath Babu, Director, Kilper, Shri Revaya Odayar, Research Head, Kilper, and our very own YG Murlidhar sir, for guiding us, motivating us, inspiring us to organize this particular event. As we all know that billions of people in India suffer and die due to foodborne illness. Consumption of unsafe food still costs India as high as billions of rupees annually, as foodborne diseases cause high morbidity and mortality. Access to safe food is still a mirage to a large section of the people, and food safety is still unresolved agenda. The mechanical, technological and biological advancement realized in the past few years has allowed a regional and nationwide food production system to expand into an international global market. Today we have access to relatively cheap and fresh products from around the world, even in the local grocery shops. Those steps have been taken to ensure that the products sold meet the required standards. Food contamination does occur, putting a large number of people potentially at risk of developing various illness. Through the implementation of Food Safety and Standards Act, better outcomes are possible with the joint involvement of public agencies and consumers. Building a strong food safety network, ensuring that all of us eat the safest possible food, strengthening the existing collaborations among all stakeholders, and ensuring the journey of the food from the farm to the fork is safe is the need of the hour. Keeping this objective in mind, this workshop is organized in collaboration with KILPER to deliberate and sensitize the stakeholders on the food safety regulation. I thank each and every one of you for having joined us today for this workshop. Looking forward to an enriching experience. Thank you. Good day.
Thank you, ma'am. Now I would request Dr. Revaya Odayar, Research Head, KILPER, to render the vote of thanks.
ವೇದಿಕೆಯ ಮೇಲಿರುವ ಎಲ್ಲ ಗಣ್ಯರೇ, ವಿದ್ಯಾರ್ಥಿನಿಯರೇ, ಮಾಧ್ಯಮದ ಮಿತ್ರರೇ ಮತ್ತು ಆಸಕ್ತರೇ, ಇಂದು ಕರ್ನಾಟಕ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆ ಹಾಗೂ BMS ಕಾನೂನು ಕಾಲೇಜಿನ ವತಿಯಿಂದ ಸೆನ್ಸಿಟೈಸೇಷನ್ ದ ಸ್ಟೇಕ್ ಹೋಲ್ಡರ್ಸ್ ಆನ್ ಫುಡ್ ಸೇಫ್ಟಿ ಅಂಡ್ ಸ್ಟ್ಯಾಂಡರ್ಡ್ಸ್ ಲೆಜಿಸ್ಲೇಷನ್ ಕುರಿತಾದ ಒಂದು ದಿನದ ಕಾರ್ಯಾಗಾರವನ್ನು ಹಮ್ಮಿಕೊಂಡಿದ್ದೇವೆ. ಈ ಕಾರ್ಯಾಗಾರದ ಭಾಗವಾಗಿ ಉದ್ಘಾಟನಾ ಕಾರ್ಯಕ್ರಮವನ್ನು ಜ್ಯೋತಿ ಬೆಳಗಿಸುವುದರ ಮೂಲಕ ಉದ್ಘಾಟನೆ ಮಾಡಿ ಆಹಾರ ಸಂರಕ್ಷಣೆ ಮತ್ತು ಆ ಗುಣಮಟ್ಟದ ಕುರಿತಾಗಿ ಅತ್ಯುತ್ತಮವಾದ ಮಾತುಗಳನ್ನಾಡುವುದರ ಜೊತೆಗೆ ವಕೀಲರಾಗಿ ಮುಂದೆ ಜೀವನದಲ್ಲಿ ತಾವು ವಕೀಲರಾಗಿ ಸಮಾಜದ ಡಾಕ್ಟರ್ಗಳಾಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸ್ತೀರಿ ಎನ್ನುವ ಒಂದು ಸಂದೇಶವನ್ನು ಇತ್ತು. ನಮ್ಮ ಎಲ್ಲ ಕೆಲಸಗಳಿಗೆ ಸಂಸ್ಥೆಯ ಎಲ್ಲ ಕೆಲಸಗಳಿಗೆ ಬೆಂಬಲವಾಗಿ ಪ್ರೋತ್ಸಾಹವಾಗಿ ನಿಂತು ನಮ್ಮ ಕಾರ್ಯಗಳಿಗೆ ಸದಾ ಹಾರೈಸುತ್ತಿರುವ ಶ್ರೀ ವೆಂಕಟೇಶ್ ನಾಯಕ್ ಸರ್ ಅವರಿಗೆ ಈ ಸಂದರ್ಭದಲ್ಲಿ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆಯ ವತಿಯಿಂದ ಹಾಗೂ ತಮ್ಮೆಲ್ಲರ ವತಿಯಿಂದ ಹೃತ್ಪೂರ್ವಕವಾಗಿ ವಂದನೆಯನ್ನು ಸಲ್ಲಿಸ್ತಾ ಇದ್ದೇನೆ. ಇದೇ ರೀತಿ ಒಂದು ಈ ಸಂದರ್ಭದಲ್ಲಿ ನೆನಪಿನ ಕಾಣಿಕೆ ಕೊಡುವುದರ ಮೂಲಕ ಅವರಿಗೆ ಹೃತ್ಪೂರ್ವಕವಾಗಿ ಈ ಎರಡು ಸಂಸ್ಥೆಗಳ ವತಿಯಿಂದ ಕೃತಜ್ಞತೆಯನ್ನು ಸಲ್ಲಿಸ್ತಾ ಇದ್ದೇವೆ. ಕರ್ನಾಟಕ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆಯ ಚಟುವಟಿಕೆಗಳು 18 ವರ್ಷಗಳಿಂದ ನಡೀತಾ ಬಂದಿವೆ. ಈ 18ನೇ ವರ್ಷದಲ್ಲಿ ನಿರ್ದೇಶಕರಾಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸತಕ್ಕಂತಹ ನಮ್ಮ ಶ್ರೀ ಕೆ ದ್ವಾರಕಾನಾಥ್ ಬಾಬು ಅವರು ಕಳೆದ 1 ವರ್ಷದಿಂದ ಅಧಿಕಾರ ವಹಿಸಿಕೊಂಡಿದ್ದಾರೆ. ಇವರು ಸಹ ನಮ್ಮ ಎಲ್ಲ ಚಟುವಟಿಕೆಗಳಿಗೆ ಕಾಸಂಸ್ಥೆಯ ಏನು ಉದ್ದೇಶಗಳಿದ್ವು ಆ ಉದ್ದೇಶಗಳನ್ನು ಅಕ್ಷರಶಃ ಪಾಲಿಸುವುದರ ಜೊತೆಗೆ ಅವುಗಳನ್ನು ಜಾರಿ ತರುವುದರ ಜೊತೆಗೆ ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ಆಯೋಜಿಸಲಾಗಿದೆ. ಇಂತಹ ಕಾರ್ಯಕ್ರಮದ ಅತಿಥಿಗಳಾಗಿ ಮಾತನಾಡಿರ್ತಕ್ಕಂತಹ ಶ್ರೀ ಕೆ ದ್ವಾರಕಾನಾಥ್ ಬಾಬು ಸರ್ ಅವರಿಗೆ ವೈಯಕ್ತಿಕವಾಗಿ ತಮ್ಮೆಲ್ಲರ ವತಿಯಿಂದ ಹಾಗೂ ಸಂಸ್ಥೆಗಳ ವತಿಯಿಂದ ಹೃತ್ಪೂರ್ವಕ ಕೃತಜ್ಞತೆ ಸಲ್ಲಿಸ್ತಾ ಇದ್ದೇನೆ ನೆನಪಿನ ಕಾಣಿಕೆ ಕೊಡುವುದರ ಮೂಲಕ. ಇನ್ನು ಕಾಸಂಸುವಿನ ಚಟುವಟಿಕೆಗಳಿಗೆ ಸದಾ ಬೆಂಬಲವಾಗಿ ಕರ್ನಾಟಕದಲ್ಲಿ ಗ್ರಾಹಕರ ಚಳವಳಿಯನ್ನೇ ಆರಂಭಿಸಿರತಕ್ಕಂತಹ ಶ್ರೀ ವೈ.ಜಿ. ಮುರಳೀಧರನವರು ನಮ್ಮ ಎಲ್ಲ ಕಾರ್ಯಗಳಿಗೆ ಸದಾ ಎಸ್ ಅಂತ ಹೇಳೋದ್ರ ಜೊತೆಗೆ ಯಾವುದೋ ವೈ ಅಂತ ಪ್ರಶ್ನೆ ಮಾಡೋದಿಲ್ಲ, ಎಸ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಆದರೆ ವೈ.ಜಿ. ಮುರಳೀಧರನವರು ಅವರಿಗೂ ಸಹ ನಾವು ಎರಡು ಸಂಸ್ಥೆಗಳ ವತಿಯಿಂದ ಹೃತ್ಪೂರ್ವಕವಾಗಿ ಧನ್ಯವಾದ ಹೇಳ್ತಾ ಇದ್ದೇವೆ. ನಿಮ್ಮೆಲ್ಲರನ್ನ ಇಲ್ಲಿ ಇಂದು ಸೇರ್ಲಿಕ್ಕೆ ಕಾರಣ ಆಗಿ ಸಮಾಜದ ಮತ್ತು ನಮ್ಮೆಲ್ಲರ ಅತ್ಯಂತ ಬಹು ಮುಖ್ಯವಾಗಿರ್ತಕ್ಕಂಥ ವಿಷಯ ಆಹಾರ. ನಾವು ಬೆಳಿಗ್ಗೆ ಚಹಾ ಸೇವನೆಯಿಂದ ಹಿಡಿದು ರಾತ್ರಿ ಮಲಗುವವರೆಗೆ, ಏನು ಊಟ ಮಾಡಿ ಮಲಗುವವರೆಗೆ ಆಹಾರದ ಗುಣಮಟ್ಟ, ಅದರ ಸಂರಕ್ಷಣೆ ಕುರಿತಾಗಿ ನಾವು ಯೋಚನೆ ಮಾಡಬೇಕಾಗಿದೆ. ಅಂತ ಯೋಚನೆಗೆ ಇಂದು ಕಾರಣಕರ್ತರಾಗಿರ್ತಕ್ಕಂಥವರು ಈ ಕಾಲೇಜಿನ ಪ್ರಾಚಾರ್ಯರಾಗಿರ್ತಕ್ಕಂಥ ನಮ್ಮ ಡಾಕ್ಟರ್ ಅನಿತಾ ಮೇಡಮ್ ಅವರು. ಅನಿತಾ ಮೇಡಮ್ ಅವರಿಗೆ ಹೃತ್ಪೂರ್ವಕವಾಗಿ ಎರಡು ಸಂಸ್ಥೆಗಳ ವತಿಯಿಂದ ತಮ್ಮೆಲ್ಲರ ದೊಡ್ಡ ಚಪ್ಪಾಳೆಯಿಂದ ಹೃತ್ಪೂರ್ವಕವಾಗಿ ನಾನು ಅವರಿಗೆ ಕೃತಜ್ಞತೆಯನ್ನು ಸಲ್ಲಿಸ್ತಾ ಇದ್ದೇನೆ. ಇನ್ನು ನಮ್ಮ ಕೆಲಸಗಳಿಗೆ ಪ್ರಿನ್ಸಿಪಾಲರು ಅನೇಕ ಕೆಲಸ ಒತ್ತಡದಲ್ಲಿರ್ತಾರೆ. ನಮ್ಮ ನಿರ್ದೇಶಕರು ಕೆಲವು ಅಗತ್ಯ ಮೀಟಿಂಗ್ಗಳಲ್ಲಿ ಇರ್ತಾರೆ. ಆಗ ನಾವು ನಮ್ಮ ಕೆಲಸದ ಒತ್ತಡವನ್ನು ಹೇರಬೇಕಾದದ್ದು ಕೋಆರ್ಡಿನೇಟರ್ ಆಗ್ತಕ್ಕಂತಹ ಪ್ರಿಯಾಂಕಾ ಮತ್ತು ಗಾಯತ್ರಿ ಮೇಡಮ್ ಅವರಿಗೆ ಹೇರಿದ್ದೇವೆ. ನಮ್ಮ ಬೈಯುವಿಕೆ ಇರ್ಬೋದು, ಜೋರು ಮಾಡೋದಿರ್ಬೋದು, ಅಂಥವನ್ನೆಲ್ಲ ಸಹಿಸಿಕೊಂಡು ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ಆರಂಭಿಸಿದ್ದಾರೆ. ಅವರಿಬ್ಬರಿಗೂ ಸಹ ನಿಮ್ಮೆಲ್ಲ ಚಪ್ಪಾಳೆಯಿಂದ ಹೃತ್ಪೂರ್ವಕವಾಗಿ ಕೃತಜ್ಞತೆಗಳು. ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ಆಗು ಮಾಡಲಿಕ್ಕೆ ಕಾರಣಕರ್ತಾಗಿರ್ತಕ್ಕಂಥ ಈ ಕಾಲೇಜಿನ ಟ್ರಸ್ಟಿಗಳಾಗಿ ಇಂದು ಕಾರ್ಯಕ್ರಮ ಆಗಮಿಸಬೇಕಾಗಿತ್ತು, ಅನಿವಾರ್ಯ ಕಾರಣಗಳಿಂದ ಆಗಮಿಸಿಲ್ಲ. ಅವರಿಗೆ ಶ್ರೀ ಅವಿರಾಮ್ ಶರ್ಮಾ ಅವರಿಗೆ, ಡಿ.ಎಸ್. ರಾಗಿಣಿ ನಾರಾಯಣ ಅವರಿಗೆ, ಪಿ. ದಯಾನಂದ್ ಪಯ್ಯ ಅವರಿಗೆ ಮತ್ತು ರವಿ ವೆಂಕಟೇಶಂ ಅವರಿಗೆ ಹೃತ್ಪೂರ್ವಕವಾಗಿ ಕಾಸಂಸ ವತಿಯಿಂದ ಮತ್ತು BMS ಲಾ ಕಾಲೇಜ್ ವತಿಯಿಂದ ತಮ್ಮೆಲ್ಲರ ವತಿಯಿಂದ ಹೃತ್ಪೂರ್ವಕವಾಗಿ ನಾನು ಕೃತಜ್ಞತೆಯನ್ನು ಸಲ್ಲಿಸ ಬಯಸುತ್ತಿದ್ದೇನೆ. ಇಂದಿನ ಈ ಕಾರ್ಯಕ್ರಮದ ಉದ್ಘಾಟನೆಯಿಂದ ಹಿಡಿದು ಕೊನೆಗೆ 2 ಚರ್ಚೆಗಳಿವೆ ಮತ್ತು ವಿಶೇಷವಾಗಿ ಈ ಕಾರ್ಯಕ್ರಮ ರೂಪಿಸಲಾಗಿದೆ. ವಿದ್ಯಾರ್ಥಿಗಳ ಒಂದು ಪ್ರಬಂಧ, ವಿದ್ಯಾರ್ಥಿಗಳ ಪ್ರಬಂಧ ಸ್ಪರ್ಧೆ ಆದ ನಂತರ ಇಬ್ಬರು ತಜ್ಞರು ಮಾತಾಡ್ತಾರೆ. ಏಕೆ ಅಂದರೆ ವಿದ್ಯಾರ್ಥಿಗಳು ಏನು ಮಾತನಾಡೋದನ್ನು ಬಿಟ್ಟಿರ್ತಾರೆ ಅಥವಾ ಏನು ಮಾತಾಡಬೇಕಾಗಿತ್ತು, ಇಂತಹ ಒಳವುಗಳನ್ನ ವೈ.ಜಿ. ಮುರಳೀಧರನವರು ಮತ್ತು ಸಚಿನ್ ಅಚಿಂತಲ್ವರ್ ಅವರು ಮಾಡ್ತಿದ್ದಾರೆ. ಆ ಭಾಗವಾಗಿ ತಾವು ವಿದ್ಯಾರ್ಥಿಗಳಿದ್ದೀರಿ. ಆ ವಿದ್ಯಾರ್ಥಿಗಳೇನು ಪ್ರಬಂಧ ಮಂಡಿಸಲಿದ್ದೀರಿ ಅವರಿಗೆ ಹಾಗೂ ಆ ಪ್ರಬಂಧ ಮಂಡನೆ ಆದ ನಂತರ ಅವುಗಳ ಕುರಿತಾಗಿ ತಾವೆಲ್ಲರೂ ಚರ್ಚೆ ಮಾಡಬೇಕು. ಆ ಚರ್ಚೆಯ ಭಾಗವಾಗಿ ತಾವಿರ್ತೀರಿ ಮತ್ತು 2 ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ತಜ್ಞರಾಗಿ ಆಗಮಿಸಿದ್ದಾರೆ. ಅವರಿಗೆ ಮತ್ತು ತಮ್ಮೆಲ್ಲರಿಗೆ ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ಆಯೋಜನೆ ಮಾಡಿರ್ತಕ್ಕಂಥ ಎಲ್ಲರಿಗೂ ಸರ್ವರಿಗೂ ಪ್ರತ್ಯಕ್ಷ ಮತ್ತು ಪರೋಕ್ಷವಾಗಿ ಕಾರಣಕರ್ತಕ್ಕಂಥ ಎಲ್ಲರಿಗೂ ವಂದಿಸಿ ನಾನು ಮಾತು ಮುಗಿಸ್ತಾ ಇದ್ದೇನೆ. ಜೈ ಹಿಂದ್, ಜೈ ಕರ್ನಾಟಕ.
I would like to especially thank Revaya Odaya sir for the immense support for conducting this workshop. Thank you, sir. Tea with a good day biscuit makes my day. I'm sure everyone is slightly hungry. Now we will have a break for 10 minutes.
After the tea break, please come back and assemble in the same hall.
Good afternoon, one and all. So wishing all the very best to all the participants. So the first presenter for the day is Eva Emima E.
A very good afternoon to everyone. I'm Eva Aruna. I'm doing my LLB in Bishop Cotton Women's Christian College, and my topic is deceptive food advertisement. With the rising trend in a healthy diet and better nutritional choices among young viewers, the drastic increase in health claims and food advertisements cannot go unnoticed. Misleading advertisement is any published claim that gives the consumer an incorrect understanding of the product that they are interested in purchasing or using. Under consumer law, advertisements are considered to be deceptive when the facts stated in such advertisements are not true and misleading and may have a negative effect on the buying decisions of the consumers. So basically, advertisement is any promotion or a marketing communication that is done to promote a company's product or a service to the targeted group of the consumers. So advertising can be basically divided into institutional advertising and product advertising. Institutional advertising is done to promote a company's image on the whole. So basically we can take Apple. So when they give out advertisements, they don't go specifically to one product, but they promote the company's image on a whole. Product advertisement is done to promote a particular product of a company. Advertisements, as stated, can have both a positive and negative impact on the buying decisions of consumers. Deceptive advertisements are misleading statements or false claims or exaggerated promises that are published by a businessman or his advertiser to influence the consumer and urge him to act in a way that he normally would not do. The definition of deceptive advertisement is given under the Consumer Protection Act of 2019 as an advertisement which falsely describes such product or service or gives a false guarantee to or is likely to mislead the consumer as to the nature, substance, quantity or quality of such product or service, or conveys an express or implied representation which, if made by the manufacturer or seller or service provider thereof, would constitute an unfair trade practice or deliberately conceals important information. So basically, this definition can be divided into 4 subheadings, which is false guarantee. So basically, deceptive advertisements give a false guarantee to the consumers. An example for this is the mango drinks like fruity, maza, slice and all. They tell us that it is 100% natural, wherein the flavors are artificial. It is not 100% pulpy mango, but the flavors that are induced inside these drinks are artificial. Next subheading is falsely describes such product or service. So basically we can take an example of Horlicks. Horlicks gives this advertisement. We're all familiar with that advertisement, taller, stronger and sharper. So that advertisement is a false description to the product because that actually isn't the reality when you consume the product. Next, the third point is unfair trade practice. So anything that a advertiser does to induce unfair trade practice is also considered as deceptive advertisement. An example for this is Tata iodized salt. So when it comes to salt, it basically doesn't have that much content of iodine. And Tata, they specifically say in their advertisement that they give consumers iodized salt, which is deceptive in nature. The fourth point is if it conceals important information. Deceptive advertisement is basically this. If it conceals a basic information that has to be brought to the
consumers notice, then it is also considered to be deceptive in nature. For example, the drinks that we daily consume, Coke and Pepsi, they contain caffeine. The statement it contains caffeine is only, put in the label and not in the advertisements. Next is the effects of deceptive advertisement. So deceptive advertisement basically it violates the rights of consumers. So consumers are guaranteed certain rights under section 2(9) or 2 subsection 9 of the Consumer Protection Act, and deceptive advertisement seems to violate those rights. The consumers have the right to choose, right to be informed, and right to be safeguarded against the potentially unsafe food products. Next, it influences the consumer's thoughts and buying decisions. So when you basically see an advertisement, you will be having that complete urge, and as a girl, I'll see something and I'll want to buy it immediately. So it will change your thought process, and as a consumer, your buying decisions will also be affected. It also brings harms to the consumer. So when you actually conceal an information that has to be given to the consumer, he or she takes to take the wrong decision, and it might affect their health indirectly. So if you take Coke for example, if you consume Coke a lot, caffeine is not good for your health. So basically you will be sleep deprived. It might also lead to depression and anxiety in some cases. The legislations that are brought to abolish deceptive advertisements are the Consumer Protection Act, the Food Safety and Standards Act, and the Advertising Standards Councils of India. So first I'd like to talk about the Consumer Protection Act. The Consumer Protection Act was actually established in the year 1986, and then it was amended to the year 2019. It protects the interests of the consumer, and we all know that there is a 3-tier quasi-judicial mechanism under the Consumer Protection Act, which is called as the District Commission, the State Commission, and the National Commission. So when a consumer has a grievance, he can approach any one of these 3 and get his redressal. As I previously mentioned, the rights of the consumers are safeguarded under Section 2, subsection 9 of the Consumer Protection Act. Food Safety and Standards Act. Food Safety and Standards Act is the main act that will be dealing with misleading food advertisements. So Section 24 put forth some principles and guidelines that every advertiser should follow, and make sure that his or her advertisement isn't deceptive. Section 52 and Section 53 lays down the punishment, which is when in case they actually deceive the consumers using deceptive advertisement, they can seek redressal under Section 52 and 53, wherein the punishment is 5 lakhs, basic 5 lakhs. It can extend up to 50 lakhs. The manufacturer will be charged a fine up to 50 lakhs. Yes. Next is the Advertising Standards Council of India. It deals with the complaints from the consumers and industries. Industries are also affected by deceptive advertisements because they are also competitors in the same field. Like if Complan gives one advertisement saying that you will grow 2 times taller, it will be a threat to Boost and other energy drinks. So Article 1A of the Constitution not only assures freedom of speech and expression, but protects the rights of the person who is in the receiving side of the expression. But in Tata Press Limited and Mahanagar versus Mahanagar Telephone Nigam Limited, it was held that the rights of consumers are not safeguarded under Article 19(1)(a). Some examples are given here. I want to specially mention Complan because I was a consumer of Complan, and as you all can see, I haven't grown even an inch more than 5 feet. So you don't grow 2 times taller when you consume Complan. And Saffola Total is an oil where they mention that it is pro-health conscious, pro-heart conscious. But we all know oil, cholesterol, and it very badly affects your health. To conclude, I would like to tell you that deceptive advertisements are still a reality in spite of the legislations and government provisions. Steps must be taken to abolish such advertisements as they violate the rights of consumers. Thank you.
Thank you, Eva. That was a great presentation by you. So the second presenter is Atira Matthew.
Good afternoon, panelists, and good afternoon, everyone present here. I'm Atira Matthew. I'm a third semester BA LLB student from School of Law Christ, and I should be presenting my paper on food advertisement standards in India, a critical analysis. Now, to start off, I would like to quote the American industrialist Henry Ford. Is that more audible? Sorry about that. Stopping advertising to save money is like stopping your watch to save time. So now, what exactly are advertisements? Advertisements basically refer to a practice that is undertaken with the aim to sell a particular product or service to the target audience. Now, what are the objectives of advertising? If you ask me, I would say it's mainly four things. Firstly, to make the consumer aware of a particular product. Secondly, to persuade that particular consumer and to create a particular lasting impression on that particular consumer. Thirdly, to sort of remind the potential customer about that particular product. And finally, like any other component in the marketing mix, to create demand and for sales promotion. So now, before going into the pros and cons of the various guidelines that have been put forth by the Food Safety and Standards Authority, we should look into the international conventions that sort of deal with food advertisements. So firstly, there is the UNCRC of 1989. Then there is the Codex Alimentarius of 1963, as well as the Trade and Food Standards of 2017. Now, looking into the laws that relate to advertisements in India, there is no central legislation per se as of now which deals with advertisements in India. But there are various other national legislations that deal with various sectors in India. So we could mainly broadly sort of divide them into three sort of heads. Firstly, there are the media-specific laws, which could be seen. Then there are the laws which protect mainly with reference to society as well as the consumers. There are also the industry-specific laws. And I would generally categorize the Food Safety and Standards Act of 2006 within this broad category. So now the advertising market in India is mainly regulated by a non-statutory body, and that is the Advertising Standards Council of India. Now, with regards to the validity of advertisements, and firstly the constitutional validity, I would say that it gains its constitutional validity from Article 19(1)(a) of the Constitution, which basically refers that everyone has the right to freedom of speech and expression. Now, this is not a right that is absolute, and there are reasonable restrictions to the same, which has been stipulated under Article 19(2) of the Constitution. Now, moving on to instances of violations of the guidelines that has been put forth by the Food Safety and Standards Authority, as well as instances of gross misuses and misleading advertisements being put forth today. One such thing that most of us might have seen is that of the Patanjali Ayurved product. So in this particular advertisement, if you see, that is of the Patanjali Ayurved mustard oil advertisement, it is basically stated that the other mustard oil companies had basically used a particular refined oils and other chemicals in their products, and it sort of this advertisement misled the consumers and created this unwanted panic and fear in the consumers. And therefore the Food Standards and Safety Authority had basically stated that this was misleading and had issued directions against the same, because these were claims that were unsubstantiated. Now, the other advertisement that is that of Boost, which again, ma'am had said if Boost worked, ma'am, but even for Boost there were claims that were made against the same. So a claim that was made that it actually included 3 times more stamina than any Sadharan drink. This again was a violation of Section 24 of the Food Safety and Standards Authorities Act, wherein, because this is again misleading and it's a false claim which is not scientifically proven, although it has been stated that it's scientifically proven. Now the role of judiciary. So the judiciary has played a very important role in this particular instance. It is in many instances sort of helped and come forward to protect the interests of consumers, but at the same time has ensured that the guidelines that it issues is not arbitrary in nature. So one such case is that of Horlicks Limited versus Zydus Wellness Product Limited. So the ad that is seen in the slide was the cause of action for this particular case. So in this case, basically Horlicks Limited had approached the Delhi High Court because the defendants in this case, that was Zydus Wellness Product, in their product Complan ad had stated that 1 cup of Complan is equal to 2 cups of Horlicks. And in this particular case, the court had held that this was disparaging the competitor's product and was misleading and was unsubstantiated. Now, another case is that of Marico Limited was Adnani Wilma Limited. So this was the ad that was put forth, which was again the cause of action for this particular case, and it was a 2013 case. Now, in this case, this was actually a case where the court had held in favor of the defendants. So here, Marico had actually filed an injunction suit against the defendants here, because the defendants, that is the Fortune Oil, which is one of the products was Fortune Oil, in their advertisement had stated that the oryzanol content in Fortune Oil was a lot higher than Saffola Gold, which was the product of its competitor Marico. And they basically sought for an injunction and stated that they disparaged their product. But the court in this case stated that this was not a misleading advertisement as their claims were substantiated and they were not trying to disparage their advertisers, their competitors, but rather that they only compared the advantages of this product with that of the other. And therefore it was not to be deemed misleading or unsubstantiated. And therefore it shows us how the judiciary has played not only a role in protecting the consumer's rights, but also ensuring that these guidelines are not arbitrary in nature. So now going on to a few statistics, we see that most advertisements today actually do not comply with the standards that have been put forth by the Food Safety and Standards Authority. And a few reasons for the same would be, I would say there are mainly 4 reasons. First is promotion of a food item with a gift, that is amounts to about 57%. Now use of a celebrity picture and package, that is about 19%. For example, use of Amitabh Bachchan on Maggi packets. Then there are false claims, 14%. And finally, appealing cartoons, that is about 10%. And that is especially for products that are marketed towards children, for example, chocolates, chips, etc. Now suggestions. So now the Food Safety Standards Act, as well as the various guidelines that has been put forth by the Food Safety and Standards Authority, especially the Advertising Claims Regulations of 2018, has been quite broad in scope and has been able to address a lot of issues. But I would, one thing that I believe would be able to make it more effective and efficient in nature is considering that certain provisions be added which specifically address social media platforms, as with the onset of COVID-19, we see that all of us are on social media a lot more. And social media has become excessively sort of beneficial for producers as an advertising medium, because it's lower cost than most traditional sort of forms of advertising, such as TV advertising, and it's able to sort of reach beyond boundaries and beyond national boundaries, and it's able to reach people of different age groups as well. And one such product that was sort of very almost solely sort of advertised in that manner was Takis. And now provisions need to be there in this particular aspect, because this is a field that's highly unregulated, not just in the international sense, but even within the Indian sort of jurisdiction. And therefore I believe that if more regulations are brought in within this, the act would become more effective in nature. Now basically to conclude, as said earlier, the guidelines as well as the act that has already been put forth has been quite wide in scope and has been quite effective in nature, but misleading advertisements continue to sort of plague the country. And therefore more penalties as well as more specific sort of provisions that specifically address the sort of upcoming challenges of the world need to be added so as to ensure that these challenges are mitigated. Now to conclude, I would like to conclude by a quote by David Overtley, who is the British advertising tycoon who is also monikered the father of advertising. Advertising is only evil when it advertises evil things. And with that, I would like to end the presentation. Thank you.
Thank you, Atira. The next presenter is Harshita R.
Good morning, everyone. Have you all purchased any product after seeing a glamorous, attractive advertisement with your favorite celebrity in it, and then which has successfully convinced you to buy the product, and you later realize after coming home or using it for several months that the product failed to reach to the claims in the advertisement? Or did you really consume booze for a lot of months in order to boost your memory, and it did not work during exams, and it definitely did not boost your memory during exams? Well, that, ladies and gentlemen, is how powerful an advertisement can have an impact on its consumers, and is an unfortunate example of deceptive and misleading advertisements relevant in our country. Good morning, everyone. I am Harshita R, and I am from 6th semester 3-year LLB BMS College of Law, and the topic that I am presenting on today is the prevalent study of delusive advertisements in India and its regulation. Well, after globalization, India rapidly started embracing consumerism, where the consumer was treated as a king and was provided with tons of variety of products in order to choose from. However, this led to a rise in competition in business, and most companies resorted to attractive, fancy advertisements in order to lure the customers to buy the products against that of its competitors. It is exhausting as a consumer for me, and I'm sure for all of us, to read every small feature on the label of the product. But a 30 seconds advertisement, an effective 30 seconds advertisement, can successfully convince all of us to buy the product even if we are not in need of it. So most of the times when you watch an advertisement, you're actually not in need of that product. But because the advertisement is so influential, so impactful on us, without even giving it a second thought, we quickly purchase such a product. However, most of the times in most products, this strategy is used at the expense of the consumers through propagation of misleading information. And this concept is called as displaying misleading advertisement. So what is misleading advertisement? As my friends already stated, the Consumer Protection Act 2019 says a misleading advertisement is an advertisement which falsely describes such product or service, or gives a false guarantee to, or is likely to mislead the consumers about the quality, quantity, the nature, the substance of the product, or is likely to convey an express or implied representation which is made in order to constitute an unfair trade practice, or deliberately conceals important information. So it is very important to note that not every advertisement is a misleading or deceptive advertisement. For any advertisement to become misleading or deceptive, the essence, the element of deception is important to it. So when we see an advertisement of a burger or a pizza, the burger in the advertisement looks as big as the size of a human being. But we know in reality that's not true. It's as small as the size of our palm. However, that is not a deceptive advertisement. It's just an advertisement which is made to glorify the product. So that doesn't fall under the ambit of deceptive advertisements. So for any advertisement to be deceptive or to fall under the category of deception, it has to be untruthful, and dishonest claims about the product should be made in order to fool the consumers or force the consumers or hide any basic information from the consumers. So what is the impact? I'm sure Fair & Lovely ad is the most OG ad of all times, where they've always claimed to make a person 10 times fairer or even more successful in work environment. They have claimed that if you use Fair & Lovely and go to a job interview, there are chances that you can get selected rather than a normal person being selected. So what is the impact of such false and misleading advertisements on the consumers? Firstly, it clearly violates the right to information. Since I've already stated, a lot of products has lengthy and long labels with a very fine print, and the consumers don't even make an effort to read such fine prints and lengthy prints. So, and there are also a lot of products which substitutes the basic ingredients with fancy words. For example, instead of just mentioning the word sugar, it is mentioned with sucrose, fructose, dextrose, corn syrup. All of this is done in order to hide the most essential and basic information from the consumers and to trick them into buying the product. Secondly, violates consumers' right to choose. Most of the products, as you see, claims a very fancy results in the advertisement. However, at the end of the advertisement, there is a small asterisk mark which says conditions apply. How many of you really think are going to go and read the conditions apply? And nobody is even going to notice that there is a small asterisk mark in the end which says conditions apply. So that clearly violates the consumer's right to choose. And lastly, violates consumers' right to safety. This is one of the most dangerous form of advertisement because it is a health hazard and it has a very severe impact on the health and safety of the consumers. As you can see in Consumer Education and Research Society versus Godrej soaps, Godrej, as we all know, is a very reputed and a gigantic hair dye manufacturing company. In this case, the hair dye manufacturing advertisement alleged that the product was very safe, organic, free from chemicals and completely harmless. However, the results showed that the agent which was used in the manufacturing of the product caused tumor because of the carcinogenic agent which was present in the dye. The second one is Dabur India versus Colortech Meghalaya Private Limited. In this case, the following principles were laid down by the Delhi High Court. The first one is the advertisements are protected under Article 19(1)(a) as a commercial speech. So every advert is free to exercise your freedom of speech and expression under Article 19(1)(a) of the Constitution of India. However, such an advertisement must not be false, misleading or deceptive. That is, it should not be done with an intent to fool or trick or deceive the consumers. And there are certain cases where the advertisement must not be taken as false, but as a glorious representation of one's own product. Like I stated, the pizza and the burger advertisements. It's just a glorious representation, therefore it should not be taken as a false or misleading advertisement. And lastly, only when the impugned advertisement goes beyond glorifying its product and is deceptive and misleading, the protection under Article 19(1)(a) of the Constitution will not be available. So how are these false and misleading advertisements regulated? As we can see, the Food Safety and Standard Authority of India, also known as FSSAI, is responsible for protecting and promoting public health through the regulation and supervision of food safety. So Section 24 of the Act clearly states that no advertisement shall be made of any food which is of misleading or deceptive nature, and no person shall engage himself or herself in an unfair trade practice for the purpose of promoting sale, supply, use and consumption of articles, food articles, and also no advertisement shall give public any guarantee regarding the efficacy of the product if they have no scientific backing. So a product which just merely claims that your memory is going to boost 10 times or you're going to become, by eating just Kellogg's Special K, you can get thinner in 7 days without exercise or diet, then that is a false claim. And that will be, the advert will be held liable under Section 24 of the Act. And the Advertising Standards Council of India, which is a voluntary self-regulation council, also works in the interests of the consumers, has signed an agreement with FSSAI to safeguard the consumers from misleading claims in the food and beverage industry. So the Act also prescribes a penalty under Section 53. So any person who publishes or is a party to publication of any advertisement or falsely describes any food or is likely to mislead the nature or substance of the quality and give false information to the consumers will be held with a penalty which may extend to ₹10 lakh. Like Sir said, there is no imprisonment here, it's only a corrective measure which is taken. Therefore, it's just the penalty of ₹10 lakh. These are some of the giant brands which were prosecuted by FSSAI. Close to 38 cases, 38 giant brands were sent notices. Yeah. However, these are the 5 most well-known, commonly known products which were prosecuted by FSSAI. So there's Complan, Boost, Kellogg's, Special K, Bonvital, Richams and Pediasure, all of which violated Section 24 of the Act. And this is a very recent press release by FSSAI that was released on August 16, 2022, where FSSAI conducted a nationwide campaign against adulteration in edible oils. So they seized close to 4,431 surveillance samples of vegetable oils, which they doubted to be adulterated, these brands or these samples did not have a scientific backing as to what was really present in their edible oils. So more than 27,500 liters were seized by FSSAI, and the investigation for the same is on the go. These are the most recent cases which happened in the last week. The first one is Johnson & Johnson baby talc. The giant brand withdrew itself from manufacturing the talc globally because of the severe health impacts, including ovarian cancer. And like my fellow friend also stated, Baba Ramdev's Patanjali Ayurveda, where a lot of these oils, mustard oils, jam, all of this did not have any scientific backing as to how pure, organic and chemical free like it claimed to. So the conclusions, I would like to conclude my presentation with a few suggestions. Firstly, in order to regulate the misleading advertisements, there has to be stringent laws imposed and hefty penalty more than 10 lakhs. And corrective advertisements should be taken at the cost of the advertiser. So not just bringing the advertisement down, but those advertisements should also be corrected and again republished or put on the print media. And thirdly, before any advertisement is made public, it has to be examined thoroughly. And awareness among the consumers should not be undermined, because consumer is the king and the king should not be fooled. And like Dwarkanath sir rightly pointed out, the law students like us can also play a very important role in spreading the awareness through workshops. Thank you all for your time.
Thank you, Harshita. The fourth presenter, J. Anbu.
Good morning, all and all present here. My name is J. Anbu, 8th semester, BA LLB, Soundarya College of Law. I am going to present my paper is Role of Food Safety Officer in Ensuring Safe Food. Without authority, we are unable to enforce our law. They are the safeguard of the law which is enforced by the government. Before I am entering into the topic, we get to know what is food. Food is any substance or product with processed or semi-processed or unprocessed. It's intended to be or except to ingest by the humans. Which means food we know everyone we get know still morning from evening we are consuming food. That food we have to not harm to our body. It's help to the growth. That's the food. If the something is harm to our body, that's we can't consider as a food. If the food not only for the humans, as animals, birds, which are in the world, every day-to-day life they are consuming the food. So food is the basic necessary. But in our Indian constitution, nowhere enacted in the food, but we can interpret Article 21, right to life. Right to life is basic need. Without food we can't lead the life, right? Everyone we need the food. So Article 21 very clearly says the right to life. That means that we need the food. That's our right. So that food we have to eat the good one that is ensured by our government. The aim of the Food Safety and Standard Act 2006, main aim is to be public health and consumer interest. What we eat, what we don't eat, that's our waste, customer waste. If we are as our colleague friends, everyone mentioned in the fake advertisement, everyone they are explaining there some of different ingredients, but we are going to there is not like that, like a Boost, Complan, Maggi. Maggi one good case we already registered in 2015. Very good judgment also came if the food that Maggie is representing MG, not added MGS, but that basically that is added on MGS. So that everyone we get to know 2015, every shop and display from they are removed from within the 72 hours. And after that they are regulating now also, but that time that is not, that says that product itself says that there is no MSG, but there is ingredients is there. So that like if the customer want to get to know if we want to consume or not consume, that's based on their wish, but they have to get to know what's the ingredient, it's the product. The Authority of Food Safety The Food Safety and Standard Authority under the Food Safety and Standard Act 2006. It's a primary law regulates in the food production. It also set up the formally enforcement of food safety and standards in India. The appointment of food safety officers by state level. This officers is controlled by Ministry of Health and Family Affairs. Now I am moving on to role of food safety authorities. This one of the most ingredient in the this act. As I mentioned that before one act is there is not that much important for the authorities panel. This act given more importance to the authority and authority panel. This is the authority panel, 22 members, one is chairperson, along with that scientific committee is one of the most important panel here. It's math, chemistry and laboratory implemented more than the old act. This is confirming that they give the right to inspect, they have the right to go any of the manufacturing company enter and they can take the example of the food. If there is anything adulteration or anything misrepresentation, they have the right to make the right to cancel the license or terminate the license, or they have imposed the fine penalties. They have the rights. Without authority, we can't implement any law or regulation within the country. They are the safeguard of that legislation. Their main job it should be protect the human. The main job it should be ensure the sanitary creation of preparation of food and the ensuring to the healthy food for the humans. And along with that, they have so many secondary job also. That's ensuring the proper labeling and representing enforcement of act. Take sample from to the all the manufacturing companies. If there's the food plant from to our table, they have so many chain processes happening. Each process they have the loophole of the adulteration. They have to stop that one. They are doing their business for controlling to the adulteration or misrepresentation, all the things. Which are the grievances can be addressed to the food safety authorities? These are the things. The main thing is violation of this act. Anything is went wrong, they are violate to that act. They have the enhanced to control over on that problem, and they have food poisoning, food adulteration, misleading advertisement. Advertisement we won't want to tell again and again. Our friends are very clearly explained about that food advertisement. These are the department they have the enhanced to control over, and if anything is went wrong, they are the authority to stop there itself, and they have imposed fine or they have the authority to cancel the license itself. Here I am going to conclude my words.
Thank you, Anbu. The fifth presenter, Sneha JS.
in for 10 minutes, so I'm sorry for that. Good afternoon to one and all present here. I'm Sneha JS from 6th semester BA LLB. So I want to start by saying, let's say for example, I'm imagining all of you to be healthy. So as a result, what I'm doing is, I am coming up with an idea to advertise a product to all of you. This is called Sneha Nutri Biscuit, and what I'm trying to say is this biscuit is high in fiber, good for digestion, and it's 100% healthy. So what would you do? I believe you people, whenever you go to, this is the assumption I have, as you people, when you go to market, you are going to buy something that has health claims in it. And I believe that, you're going to buy this product, everyone has bought this product and you have left. And I am also happily going back home that my product sold out. But then when I go back home, I realize, I'm like, oh my god, I forgot to tell something. I told it is high in fiber, good for digestion. But I forgot that it also has a lot of sugar in it. It is high in sugar. So this is what advertisements are in today's scenario. We look into the positive. We concentrate so much on the positive that we forget about the negative. We believe the claims that are positive and we forget about the negative. And with that note, I would like to start my presentation. The topic for my presentation is consumer choice based on food advertisements. From a legal perspective, special emphasis on brands and claims. So these are the research questions. The research methodology used was both doctrinal and non-doctrinal. So what were the research limitations was that I used only packaged goods. Secondly, only more emphasis on audio-visual kind of advertisements. And there was a survey conducted based on an experiment, and it was limited only to the consumers of BMS College of Law. Now let's move on to what is an advertisement. So basically, when you talk about advertisement, what is the history of advertisement? Since human beings were alive, since civilization came into place, advertisement has been in place. So over a period of time, what happens is there is a growth and globalization, urbanization, industrialization. So many people want to sell the similar products. So at that point, what happens? Even I have a packet of biscuit, the other person also has a packet of biscuit. How will a consumer differentiate? In this point, what happens is the seller cannot just say, these are the quality of my product. He has to differentiate the product, and that is when branding will come into place. I will talk about branding in the next coming up slides. Now let's go into the definitions. So when you talk about definitions, FSS Act as well as the CPA Act talks about definition. There's only some slight changes. So if you say what is the definition under the Food Safety and Standard Act, it is an audiovisual representation or publicity by means of gas, smoke, light, etc. And it also includes labeling, invoice, etc. So what is the change in CPA Act, the Consumer Protection Act, is that it includes endorsement in it, and that is the only change. Now what is a brand? Why do we need a brand, and what is a brand? So basically, as I said, when everyone has a similar product, you need to give an separate identity to the product, so a consumer can choose that product over the other product that is available. And that is what brand is. Brand is basically a name, design, logo, or anything through which you can specify this product as a differentiator product. So what is the psychology behind brand? Now we have, as human beings, we have unconscious thinking and conscious thinking process. So unconscious is basically like you get up, you go brush your teeth, you don't think, should I brush? You don't go in front of the mirror, okay, I don't think like brushing today. No, we don't do that. We are like, okay, today we have to brush our teeth. That is like unconsciously it comes into your brain. That is the way brands are using advertisements today. They are trying to unconsciously build a brand identity to such an extent without thinking you want to choose that particular brand. Now, to understand this better, we did a field study. So these were the images shown to the students. One by one they were shown, and they were given a 45 seconds gap, and they were asked to tell whatever came to their mind. And the situation was that, how would you ask this product in a grocery store? So interestingly, we got 163 responses. Among that, 139 responses were related to brand association. They associated the product with the brand. Only 24 of them did associate with the brand. And another interesting fact is, when I showed this picture, 119 out of 139 denoted to Maggi noodles. So yes, because they denoted to Maggi noodles, we need to know what is the case of Maggi. Maggi was entered in India in 1983. First they targeted women and then it was a failure. So they started targeting children. So then what happened, as we all know, 2015 there was a case, 6 months ban. Interestingly, at that time also people wanted to go into black market and get the product. That was the demand for the product. Finally, what happened, there were two petitions that were filed. One was because they banned Maggi in Bombay. For that, they asked what was the contention behind banning. They didn't use the government didn't use the procedure that was supposed to be used, and they were not they were against the principles of natural justice. So the ban was withdrawn. But until today, the case is there. It's still running in the National Consumer Redressal Commission. The last update, the latest update came up in 2019, and this claim of no MSG claim and there was more MSG and all of that. Yes, it is true. But what happened here was they had sent the lab report to a laboratory that was not accredited according to the Food Safety Standard Act, and that is where the entire problem happened. Now moving on to misleading advertisement. When does an advertisement become misleading? Again, Food Safety Standard Act, CPA Act, both talks about this. So common terms, it should not be misleading, it should not be deceiving, and it should not be telling a wrong quality or quantity that is actually not true. So these are the common terms. Importantly, recently there was a guidelines for prevention of misleading advertisement in June 2022. According to that, in section 4, it says certain circumstances under which an advertisement can be said, that it is not misleading. There are 7 circumstances. Few of them are: it should have truth and honest representation, there should not be exaggeration, and they should not make universal claims if there is a difference of opinion, and so on. Now, what is advertisement puffery? Advertising puffery is a new term. I mean, most of us may not know this term. So basically, it is a defense for misleading advertisement. Normally, when you say you look into slice advertisement and all that, fruit juice advertisement, you feel that they're telling it is coming from a mango. How is it possible? Why aren't people contending against it? It comes under the concept of advertising puffery. So advertising puffery is nothing but an advertisement that cannot be falsified. It comes under advertising puffery. To give you a simple example, let me take 2 juices, fruit juices. According to FSS regulation, you need to have up to like 15% pulp in the let's take a mango juice, slice, and there is another XYZ juice. In that XYZ juice, 2% pulp is there of the fruit juice, and another the slice, there is 15%. So this is according to slice is according to the FSS regulation, but the 2% juice is not according to the last 2 minutes. Okay, it is not according to the FSS regulation. So here what happens is, because slice is according to the FSS regulation and it has 15% pulp in it, it comes under non-falsifiable advertisement and it comes under advertising puffery. But the 2%, the other juice I said, the XYZ juice, will not come under it because it doesn't follow the regulation, and hence it will come under the category of misleading advertisement. Now when you talk about claims in advertisement, I will be adding few points in the suggestions as well. Basically, for example, when I say this product, Nutri-Choice digested biscuit, yes, they might be according to this regulation that was there in the FSS Act regulation, but do we understand what it is? Yes, I can understand. I read the regulation. The regulation says 6 grams of fiber is there. Yes, it is high in fiber. How many of us know about it? We just go to the, we go purchase the product and then we are like, yeah, this is high in fiber, so it's good for health, I'll take it. Now moving on to the suggestion. I started with brands. So basically why I try to bring that psychological impact is because I wanted to say that brands are equally liable. They should be more liable actually. There should be a classification for branded products and other products. Like even in the by registration, FBO registration, they classify between petty operators and the other food business operators. Some kind of classification, and they should be absolutely liable for what they're doing. Because they're coming into your they're coming into your mind. Unconsciously, they're deciding what you need to do. Secondly, pre-publishing certification. You might know that movies, we need to get certified before it is published. Similarly, you can do that for advertising as well. But even ASCI code, to a certain extent, It is a self-regulatory body. Here they have the Cable Television Rules 1994. The Rules 7 of it says that they should abide by ASCI code. Can I continue for a minute?
Yeah, you can do that.
Yeah. According to the ASCI code, the Cable Television Network rule, the Rule 7 says that you should abide by the FSS Act and you should abide by the ASCI code if it should be published in a cable television. However, after this came and only we had the case of Complan, the double growth, all those cases came after this only. So we need to have somewhere like you need to keep check and then publish it. Thirdly, lack of awareness on various claims. So claims, we believe claims because we are not able to comprehend the ingredients. So if we have awareness on these claims, it would be a better way of dealing with it. And necessity of advertising puffery. So this term is only judicially termed until now. So we do not have any legislation talking about advertising puffery. If there was a legislation or if there was some kind of a definition, in which situation will it come under advertising puffery, there will be more clarity. Thank you so much.
Thank you, Sneha. The sixth presenter, Maniganda Prabhu.
Good afternoon, eminent scholars, jurists, and legal luminaries, finally panel members, and my dear students who are going to be the aspiring advocates. Thanks for this opportunity. See, I have there are options of about 6 topics. I have chosen food advertisements. How fair are they? So what I did was, instead of doing a secondary research, I tried conducting a study. It's an empirical research. So what we did was we did this analysis in 2 states. One is in Tamil Nadu, second one is in Karnataka. So I have set up a questionnaire, administered the questionnaire through 2 ways. One is direct and second one is through the Google form. Now coming to the abstract, food is an overarching needs. I would like to draw the quote of 2 people. One is that Charles Darwin, who never said the survival of the smartest, but the survival of the fittest. Hence, food is one of the overarching need among the substantial need for not only the human beings, but every living organism. Second, a recent book, an awesome book by one of the Israel author, Yuval Noah, probably most of you would have studied. The book name is Sapiens, which says out of 20 lakhs, that's 2 million years of human evolution, 10,000 years back, when the first revolution started, he quotes 3 revolutions. First one is agricultural revolution. Agricultural revolution set up the start for building of cities, which leads to the government, which leads to the law and setting up. So hence, food gains a very significant importance for everyone, including us. Second, just can you help me there to go? That's a window which has come up. Yeah. So that's about food. Second one is the impact of advertisements towards food consumption. A lot of research says that our purchase pattern, including food or even for the non-food, is depending upon the psychological or subtle information which has been passed through the advertisements that we get to exposed either in the form of channels or the movies or the social media, whatever it is. So thus it gains the significance. Like I said, it's an empirical study with 100 people I have tried because the time was little short, out of which 61 respondents have reverted back to me. Out of 61, 21 respondents I have met them and personally administered a questionnaire. Rest 40 people are through the Google form. Why I did a empirical study for a discipline of law? Because we are part of a rich democracy. Our constitution is the longest written constitution in the entire world. So in a thriving, functioning democracy, I would like to see the will of a people and what do they feel about the advertisement, especially to the food advertisement. So thus, we got this research paper. I have narrowed upon the, because since it's only a 3-4 day study, I have to travel a lot. So I have narrowed the opinion to 2 things only to answer the main topic. How fair are the advertisements? Sorry. Now definition, I think most of us have already seen the definition through the earlier participants, and we have relied upon the legal definition so that it is more comprehensive. Out of which only 2 things I am going to quote, apart from what the other panelists presenters have not covered. It's not only about food or non-food or any other products. There can be even ideas which can be advertised, and it has to be, advertisement means it has to be an advertisement or a communication done by a paid sponsor. Without a paid sponsor, it doesn't qualify to become an advertisement. Sorry. Significance, why advertisement? You would have seen, a lot of students would have seen, a lot of panelists, presenters are covering up the advertisement, because advertisement is really, really big. To give a perspective of the numbers, the size of the advertisement is equal to the GDP of a country. Say we can take it Pakistan. That's the size of the market. Indian advertising market is about 70,000 crore. This is to give us, scale of the industries into that. So why advertisement? What is the function it does, and what does it achieve? There are 4 stages into an advertisement. One is a birth, like how a human being is born into the world. First, we use advertisement to communicate a product. We call it as a trial or a birth. Second stage, continuity or a survival. For example, like we got a boost or a Complan. So it's born, and to make the sale more, to have a continuity, to have a survival, we do the advertisement. Third one is an attacking mode. What is an attack mode? For example, Complan and Horlicks are attacking each other. We call it as a guerrilla marketing. So to gain the market share, the mind of consumers from one competitor to the other competitor, they promote advertisements which call as a switching advertisements. It eats into the market share, the money share of the competitors. It's called as switching. Then the last one is switching back. For example, the Complan has eaten into the market share of Boost, say 20%. That translates into about, say, 800 crores. So now the other competitor had to take back that 800 crore which he has lost in the previous year. So for this, the advertisements are used. That's why the significance. Governing statutes, everyone have covered. Most of the predominantly Food and Food Safety and Standards Act 2006, CPA, ASCII code. These are predominantly regulatory guidelines. We using this governing statute, we prohibit certain actions, and there are penal provisions which we have dealt in very deeply. So what is the purpose of research? So I have taken 4 questions which should be answered. This is empirical research. This is not my point, or this is neither my understanding on what exactly was available in the secondary information. These are directly asked to the consumers. So how do you qualify a consumer? Anyone above 18 years of age, who is senile, who is competent to act as a party if it has to be taken into a contract act. So these are the qualifications which I have set up. So 4 questions: whether the food or product advertisements in the media platform run by food marketers genuinely represent the actual product. So the first one is genuinity. Second one, does the food product manufacturers, when they advertise, do they have a social responsibility? A lot of people make tall claims saying that we are socially responsible, but do the consumers, that is you and me, actually feel the same when we see the advertisement? That's the second question. Third, very important point, will a consumer buy a food product driven by the advertisement? Does the advertisement play a pivotal role in terms of converting a non-buyer to a buyer? And fourth point is that overall, what does a public here means that the qualified targeted audience of this research think about the fairness quotient of. Fairness quotient means, in their mind, in their opinion, is it fair? Fair means genuine or not. Methodology, I have already slightly briefed about it. Capture the responses using a structured questionnaire. Measure their perception, understand through analysis. So there is no perception. Yeah. So the findings, and I came to the last point. The researchers, it says that majority out of 61 respondents, 63% of the consumer considered that the food advertisement are not fair at all. But you look into the second point, the second data point, it says that 52%, roughly 52% of the consumer also expressed that they would buy a food product based on the advertisement. This is a contrasting scenario. So what technically, to put it in a simple way, say is that I am saying the food advertisement, whatever I have seen in the media, is not fair, but still I would buy the product. So this is where one of the researchers have validly quoted, getting to the minds of the consumers in a very subtle way, and psychologically influence them. This is one of the reflections. So what we are going to do, we have seen the findings. A legal impact for a legal students or the fraternity of our judicially or to the jurisprudence is that these kind of nuances have not been governed with a strict penal provisions, because if you go into the deeply, this is only the consumers of 18 years of age. But whereas these advertisers get into the minds of our kids, our children, unknowingly they build a popular perception using all these tools of advertisements. So we legal students should ensure that probably you or me should put up a bill and get a validity and submit to the government saying that these kind of advertisements should be controlled. Thank you, friends. Thank you, ma'am, for this opportunity. And this is my first presentation. I think students, an awesome decorum. On time we are practicing it. Thanks for the students and my friends.
Thank you, Maniganda Prabhu. And the last presenter for the day, Shweta J.
Good afternoon, everyone. I know it's lunchtime and everyone's hungry because we've been talking about food since morning, right? No, it's 1 o'clock, ma'am. Okay. So I could have used the word truth behind advertisements, but why the word candor? Anyone? It sounds fancy, right? That's what advertisements are doing to us, right? They use fancy words, fancy colors, and the branding names. So yeah, so the candor behind advertisements is nothing but candor, nothing means truth or purity, right? So advertisements, on a general note, we know what advertisements are by now. So firstly, we see them on television, OTT platforms, billboards, newspapers, pamphlets, social media, sponsors, and even events. So there's a new Netflix regulation that says for every 1 hour, you'll have 4 minutes of advertisement. So when Netflix, being an OTT platform, will be getting advertisements into it. So option to watch. Do all of us watch advertisements? But YouTube, when you're watching an interesting video, you tend to skip it, don't you? But if you see a Zomato ad during lunchtime, we definitely want to watch it because we can order based on that, right? But in television, we don't have the option to skip. And next, interesting, powerful, emotional connect. All advertisements have something interesting in them, that's something catchy, and that's something really powerful that have an impact on us. And emotional connect, when they involve something related to mother and child in an advertisement, food product, we definitely get connected to it. And what's the effect? We have psychological effect and even a physical one, because we're consuming the product end of the day. So where is the mistake? Why are advertisements termed as misleading or deceptive? It's because partial facts. The whole truth is not portrayed. When you say something is partial, it's better to be ignorant than having half knowledge. So when you're portraying something partial, you don't have the complete information to choose a product. And then false advertising. So when a product is portrayed as healthy, energetic, very rich in proteins and fiber, we definitely tend to buy it. But what is false advertising? False advertising, as many of them have said, it's basically you're not portraying what your product actually is. You're saying that it is healthy, but how healthy is it? Are you portraying the complete facts? Now let's say we have, most of us have had this energy drink called Sting, right? And this definitely gives you instant energy, but for how long? Don't you think the time period for how long this energy is supposed to be sustained in the body should also be mentioned? And finally, deceptive and manipulative. Why do we say it's deceptive? It's deceptive because we are lured into buying a consumer product related to food. Now let's say we're talking about a bag of chips. It says it's not fried, it's healthy, oil-free, but we end up eating 2 or more packets saying that it's healthy. We don't have portion control when it comes to eating food or branded products. So this is the health index, but here I know health index does not only cover the food aspect of an individual or a state, but of course food is also part of the health, one of the criteria for health index. And this is not, when you see the green part, and when you can actually even see a few states have a lot of larger numbers, this is only a comparative analysis. This is not the end product or saying how healthy a state is. It's basically saying how healthier a state is compared to its previous analysis. Now behind the scenes, most of us have seen burger commercial ads. So what's the commercial and what's real? Don't you think that is deceptive enough? And what we see in the first images, everything is deceptive, and what is second is actually the real image. So when you have the burger commercial, there are actually toothpicks inserted inside to make the product look bigger and better. And when it comes to the tart or the bakery product, they have shaving foam on the left and actual whipped cream on the right. And here when it comes to the cereal commercial, there's actually glue that has been placed in a bowl, and on top of that we have the cereal placed. But in the real commercial, there's actually milk. And in the last one, it's surprisingly maple syrup was substituted with motor oil. So end of the day, we are not eating what we actually see. We are seeing something, we're eating something else. So the milk is substituted with glue, cheese with slime, honey or maple syrup with motor oil, whipped cream with shaving cream, ice cream with mashed potato with food coloring, and cake with styrofoam or cardboard in between, and tomato sauce or red food coloring is what is portrayed. So how are we influenced? We are influenced with the packaging, endorsements, taste enhancers, use of the terminology saying healthy, safe, not fried, ready to eat, high energy, and offers. Now 10% is just a very minimalistic number. You have offers saying 50% off or 50% extra in a packet. Now use of the terminology is healthy. How many of you consider consuming oil to be unhealthy? Don't you think a basic human also requires lubricants for the joints? But advertisements have been portrayed in such a way saying that consuming oil on the whole is bad. Many of the products say oil is unhealthy fat. But a human body also requires healthy fat for lubricating the body. And here we have baked, not fried. So when given a product to me saying it's baked, not fried, I tend to consume more in the opinion that it's healthier than what I'm actually consuming on a regular fried product. And so many of them have spoken about ASCI and FSSAI. I will not go deep into it, but yes, So the Code of Ethics for Advertising in India is mainly regulated by the Advertising Standards Council of India. But if these two organizations with Consumer Protection Act were working in a functional and a very better manner, do you think we'll be having this conversation today? Definitely not. So where do we improvise? It's better to get a separate legislation for advertising specifically, or we actually betterment the existing rules for advertising with existing guidelines. And we have better measures to scrutinize advertisements before being released in the public domain. And we have cleaner labels and complete information. What is a clean label? A clean label doesn't mean it's just clean to see, but it should have the proper contents on it in an easy, understandable manner by a layman. Now, do you think a mother who is illiterate would go into seeing what the product contains? And even if she sees it, do you think she would understand what it contains? I don't think so. So when you have cleaner labels, you have complete information that is portrayed, that is used in a product. So when you see a packaging of chips, right, you see only the potato, the chilies, or whatever flavors that have been used. But nobody portrays what are the preservatives that have been used in it. Of course, you cannot portray preservatives, but don't you think there should be a clear disclaimer saying that this product has so and so preservatives? And portion control, as I said, it's only an individual can control by themselves, because nobody can come and stop you by saying don't eat this, don't eat that. Right? They can't have a regulation for that. So portion control is better when you have a complete information about the product. So how fair are advertisements is the theme. So I would definitely say that advertisements are not fair enough for us to choose a product, and they're not fair enough for us to understand the reality, the whole truth behind actual product. And definitely not transparent enough, because they're not being open enough to you as to what is being used in that product. And it's more like we have assimilative capacity, right? Because we are actually, after we undergo a tragedy, are we coming up with guidelines and regulations. So don't you think it should be more of preventive in nature? And yeah, it should be more informative and definitely not fair enough in the perspective of health. Yeah, that's it. Thank you.
Thank you, Shweta.
The presentations by students have been completed. Now we move on with the first technical session. I request Sahana PS from 6th semester BCom LLB to introduce Sri Sachin Achintalwar sir.
Thank you, Sneha. A very good afternoon, everyone. It gives me immense pleasure to introduce to you all Shri Sachin Achintalwar. Sir has a degree in Bachelor of Technology in Food Science from Marathwada Agricultural University, Parbhani, and a certified Six Sigma Green Belt from Benchmark Six Sigma. Sir has 11 years of experience in food safety and quality assurance in Coca-Cola, Novartis Medical Nutrition, Parle Agro Limited, Reliance Retail Limited, and Bharti Del Monte Field Fresh Foods Private Limited. He has 10 years experience in food regulatory affairs in VT Fine Foods, Britannia Industry Limited, AB Mauri India Private Limited, and Cloudtail India Private Limited. He was a former president in AFSTI Bengaluru chapter. He is also a member of various industry associations like FICCI, CII, PFNDAI, and AFSTI. He is coordinating various activities of FSSAI in Bengaluru in partnership with NetProfan and AFSTI Bengaluru chapter. Sir is co-founder of Legal Prax Business Solution Private Limited, Bengaluru, and is currently working as a regulatory consultant in the same. We are grateful to have you here, sir. Thank you.
I would request Principal Ma'am to felicitate Sachin Achintalwar sir. Now, I would request Sachin Achintalwa sir to talk on the topic obligation of the food manufacturers, packers, sellers, etc. under the Food Safety and Standards Act 2006.
Good afternoon. So I don't want to take much of your time because I don't want to become a barrier between your lunch. So that's the time I have been given. So it is always challenging before lunch, but I will make sure that it will not become challenging for all of you. So I heard various presentations being delivered by students, and it's really heartening to know that to what extent they are actually studying the law, interpreting the law, and also giving suggestions. So there are many changes being brought by FSSAI from the last, at least I will say 5 to 6 years to be precise. And by the time the FSSAI has been introduced in 2008 to till now, there is a complete transformation in the regulatory space from FSSAI. So we always actually try to blame the regulators or try to always criticize the regulator, but it is not the case, because at the end of the day, the people who are actually part of the various regulatory communities, including the scientific panel, scientific committees, various other stakeholders, then many other divisions of FSSAI, has been led by the people from the industry or from the academia or from the people from having experience into the regulatory affairs. So everyone is learning here, and I can proudly say FSSAI is one of the best regulatory agency who is taking all these suggestions, inputs into consideration, and they are evolving the regulatory framework as and when it is required, as compared to any other agency, because obviously other agencies are working, but if you see the way FSSAI works, the kind of updates they give, everything is in public domain, but yeah, there is always scope for improvement. So with this, I just want to start my presentation. So, any one of you, maybe you just tell why and what of regulatory. So why regulations are needed. We discussed a lot, in last at least couple of hours, maybe just couple of, any one of you can just pitch in and explain why regulations are required. Anyone? Can you do it?
To improve the quality.
Okay, sir. Yeah, what else?
Improve the quality of product.
What if there is no regulation? Yeah. What if there are no regulations? What will happen? We discussed just from the last 1.5 hours. Okay. What? Absolutely right. What else?
Consumers will be in more danger and more painful situation
Okay, great. And another important thing is, apart from whatever the aspects which you have already mentioned, is also to ensure the safe and wholesome food to the consumer. So let's understand why and what of regulatory, what kind of requirements are there. In fact, we have discussed specifically about the advertisement, specifically about the. Is it better? So let the journey begin. So we discussed a lot about various activities, various terminologies since morning, but this is the one slide which covers all the aspects which is governing the food in our country, predominantly from an FSSAI standpoint, because this is the principal regulation. However, there are many other acts and rules and regulations which are governing the food sector in direct as well as in indirect way, like with the likes of legal metrology, the Consumer Protection Act, BIS, AgMark, sanitary import permit, blah blah blah, health certificate requirement. So, as you will not go into the genesis of this, but this is just to give you a perspective how this activities are evolved over a period of time. Once the bill will be introduced in the parliament, then it will become an act. Basis the act, the rules and regulations are defined. Basis the rules and regulations, subsequently the notifications will be issued. And if there are any changes, any clarifications are required, or any changes or any further amendments are required, it has been issued through orders, direction, advisory, and obviously there will be continuous amendment as and when it is required basis the representation of the industry and basis the evolving global regulatory framework across the globe. So let's take an example of a instant flour manufacturer who wants to start his business. And so what kind of regulatory requirement they need to follow. So I'm just giving a very uber level perspective here, because in the interest of time we will not able to cover each and every aspect, but just to give a uber level perspective, obviously the principal regulation or the authority which governs the food sector is the FSSAI. You have to comply with various requirements of FSSAI, not only restricted to the licensing and registration, the advertising of the claim, the food product standard and additives, the prohibition and restriction of sales, then you have laboratory and testing regulation, then you have contaminant toxins and residue regulation, and then there are sector specific regulations. Take an example of health supplement nutraceutical regulation or infant food regulation, then organic food regulation, then there are regulations on various other specific categories which have been introduced and has been notified over a period of time. Another important thing which many of us always miss to some extent, maybe because of lack of awareness or maybe because of understanding of the regulation of the, sometimes maybe the interpretation of the regulation, is one of the important things which is an integral part of any packaged commodity covering food is the legal metrology packaged commodity rules, and that is governed by a separate ministry under the separate Act of Legal Metrology Act of 2009. And another important thing which has been given impetus by the government, especially the government which is current dispensation, they have emphasized a lot in terms of reuse, reduce and recycling of the plastic, and obviously promoting the sustainability or sustainable packaging in a more evolving way, and that's how you will see a lot of brands are now talking about sustainability in their advertisement, in the packaging, the carbon footprint, blah blah blah. But yeah, this is just a work in progress. It will take some time to evolve. And recently government has also notified, to be precise, on 16th of February of this year, government has also notified the comprehensive regulatory framework of the extended producer responsibility for plastic packaging, or whoever, for the brand owners, producers and importers. It is called the PIBO, producer, importers and brand owner, where you have an obligation if you are using plastic as a packaging material for packaging any kind of food products, because we are restricting our discussion to food product. So it is your responsibility to ensure that the equivalent quantity of plastic is collected, recycled, treated and channelized as per the norms set up by the Pollution Control Board and the Central Pollution Control Board under the aegis of Ministry of Environment, Forest and Climate Change. And this is very important, and it has already been made mandatory. So whoever are the brand owners or the marketers or the manufacturer who own that brand, they need to take the registration from the State Pollution Control Board if they are operating in that particular state. If you are operating in two or more states, you have to take a registration under the either of the PIBO, depending on your eligibility, from the Central Pollution Control Board, and you have to submit the data of the quantum of plastic which is being used in your product. So this is very important, and please keep this into mind whenever you are launching or whenever you are working on any food products. It is not only restricted to FSSAI, but also legal metrology as well as the plastic waste management rules. And then there are many other licenses which is required, like the factory license, shop establishment, NOC, blah blah blah. So we will not talk much on that, but just to give a broader perspective here. So now we will start with the FSSAI license for a particular food business operator. So just to give a perspective, like what we discussed last time, as far as FSSAI licensing is concerned, only two stakeholders are exempted, which is the farmer and the end consumer. Rest, everyone in the supply chain needs to abide by the licensing regulation depending on their eligibility criteria. For example, if someone is trading a commodity in a mandi or the agricultural produce market committee, they also need to take a license under wholesaler, retailer, trader, depending on their eligibility. Then the manufacturer, then it comes the distributor, then the depot, which is where the storage is happening. The storage is a separate kind of business in FSSAI. Then if you are importing something, you need to take an import license. If you are exporting something, you need to take an export license from FSSAI. And it will not end here. It also includes the transportation as well, which includes the primary transportation as well as the secondary transportation till it reaches to the retailer, or maybe till it reaches to the end consumer, depending on the way the e-commerce sector is growing, where there are a lot of brands who are doing D2C, which is direct to customer, where you need to ensure that the entire supply chain is licensed and following the law of the land, covering the FSSAI requirements with the likes of Swiggy, Zomato or anything. Even the food delivery people, the people who are delivering the food, they also need to comply with the basic hygiene and sanitation requirements from a FSSAI standpoint. That's where the Schedule 4 of licensing and registration of food business comes. So as you know, under FSSAI, it's a 3-tier structure. One is basically the central license or a central registration. Central registration is only for those within the central government premises like the canteen, defense, airport, blah, blah, blah. So this is the new category of registration being introduced by FSSAI, and including the stalls and or the shops on the Indian railways or airports, where those are also notified. The officers are separate for that. The Indian Railways designated officers are there who are actually authorizing licenses or registration depending on the eligibility criteria. Then for a petty food business operator, we already discussed, basically whose annual turnover is up to 12 lakh per annum. So they are eligible for registration by paying just 100 rupees fee. Then the state license and central license. State license is either, so say state and central license depends on the turnover, depending on the quantity, depending on the kind of product, and depending on the kind of business. So if you are in import, you need to take only central license. There is no other choice. But if you are a dal or a rice miller or a dal or rice manufacturer, you need to take a state license irrespective of the capacity. But if recently what FSSAI has done, irrespective of the capacity or turnover, especially for the proprietary food, for which there are no standards, specific vertical standards defined, for proprietary food you have to obtain central license irrespective of the turnover, irrespective of the capacity. So, and another important thing which has been done is basically the emerging and highly regulated sector, and where there are a lot of issues in terms of claims and justification, RDAs, blah blah blah, is the health supplement, nutraceutical, food for special dietary use and food for special medical purposes. And now FSSAI has separated out, in 2020, they have separated out the infant food category, where just a couple of days back FSSAI has issued an amendment where you need to have a BIS license for the manufacturer. Earlier also it was there, but now they have made it very clear that wherever BIS standards are available, first you need to obtain the BIS license for manufacturing from the Bureau of Indian Standard, then only you will get the FSSAI license for manufacturing the product. Another simple example which all of us know is the packaged drinking water. So unless until you don't have BIS, FSSAI won't issue the manufacturing license. So that is a prerequisite, similar to your fat spread where you need an AGMAR. Without that, you will not get the FSSAI license. Yeah, so this is just to give you a snapshot of, this is what we have discussed. The registration is up to 12 lakh per annum. It is issued by the State Food and Drug Administration, or whatever you call it, depending on the way the enforcement structure is designed. Like in Karnataka, it is under the purview of Health Department of the Government of Karnataka. And licensing, if your turnover is greater than 30 crore, as a distributor, you need to get a central license. Then capacity, if like what we have discussed, if it is up to 2 metric ton per day, you can get a state license. And storage, if you have a go down or a warehouse, if your storage capacity is up to 50,000 metric ton per day for an ambient product, which needs the ambient storage, because there are separate requirements for the products which needs the specific storage condition like refrigeration or a frozen condition or a controlled atmospheric condition. For that there are defined storage criteria. Then central license is as per the Schedule 1 of the Licensing and Registration Regulation, and the conditions of license is as per Schedule 2 of the Licensing Regulation. And like for registration, there is an application form which is called as a Form A, And for license, it is called as a Form D. We will not go into the detail, but just to give a broader perspective. And the fee is already given in the Schedule 3 of the Licensing and Registration for Business. And Schedule 4 talks about the GMP requirement, which includes safety, sanitary and hygienic requirement as per relevant part. And processing of license has to be, as mandated by law, is within 60 days from the date of filing the license. And on the contrary, if it is a registration, the authority has to issue the license within 30 days. If there are any queries, if they have any objection, they have to give in writing on the portal of FSSAI, which is now the first course. Earlier it was FLRS, which is Food Licensing and Registration System. So now, why this 30 days and 60 days timeline has been done as per the Food Safety and Standard Act? Because there were inadvertent delays, sometimes intentional delays, and many other challenges. So what has been done, if you have applied for a license, and if you don't get a license within 60 days, and if there are no queries, you are deemed to be licensed and you can commence your food business. So that's why this provision has been introduced, because it was not there in the erstwhile PFA and FPO and others Act, which got amalgamated here. Sorry. Yeah. So this is just to give a perspective. The earlier system was the FLRS, Food Licensing and Registration. This has been re-christened. It is a more user-friendly, with a higher space, with higher features, and with a lot of user-friendly features have been introduced. So this is called as the first clause. The law from the first clause is Food Safety Compliance System. It not only covers the licensing or registration, it covers if the food safety officers are inspecting the premise, they can upload the inspection report, you can upload your complete details, you can file your annual returns, even you can get all the complete end-to-end perspective here, where it will be a single database for FSSAI as well as the food business operator with your own login. You can download, you can file the return, you can respond to the notices, you can upload your test reports, you can upload your annual return, you can modify your license, you can renew your license, you can surrender your license. All those activities are being given here, and the portal is firstclause.fssai.gov.in, and you will see even on the left side here you will see all the standardized list of products. Where you just click on that, you will get a complete products which are being standardized, and it has been upgraded day by day. It will evolve day by day as and when the new standards are notified. Now the latest standard is nothing but for the hemp. I think few of us at least know about the hemp. So hemp is now recognized as a food, and now there are a lot of startups who are venturing into the hemp-based products, hemp flour, or maybe hemp-based snacks, or hemp-based beverages, blah blah blah. So all those categorization, updation, upgradation, amendments, everything is being integrated in this. And here you have multiple features: track application, know your officer. Even you will know your officer, who is your officer. You can search the businesses, their license number. You can have application processing, how to apply, blah, blah, blah. Yeah, so this is the basic this homepage, and once you create your login, you have multiple options to apply. If you are into dairy units, you just click on the dairy units. If you are into vegetable oil processing, you just click on the vegetable oil processing, slaughtering, general manufacturing, proprietary food, non-specified food, substances added to food means basically the food additives, colors, flavors, processing aid, enzymes. If you are into that manufacturing, you can just, so it's basically a very tick box approach, and depending on where you are, you can just go ahead and click on that particular window or click on that particular tab, and then apply, submit the necessary documents as being requested, and then file the application. You will get an online generated receipt of the license on the application receipt, and then you can also track your license by putting the application reference number, which will be generated through FOSCOL system. So this is the selection of a standardized product for manufacturer. So if you are a manufacturer of XYZ product, let's say this is an example for the meat, then even in that, under that particular category, for whatever the products there are which are already having the standards in FSSAI, that has also been mapped in this portal, where you just need to click on that particular product. If you are into fresh or chilled or frozen beef, you just click on that, or maybe if you are into biscuit, or if you are into bread or anything, everything is being mapped. So if you see just at bottom of this thing, there is a food category, there is a sub-food category, the product, then you have to add kind of business, whether you are a manufacturer or a repacker or a relabeler, and then you can add a number of products depending on your manufacturing products and the kind of products which you are manufacturing, and then you have to save and next and move to the next level. Yeah, so these are the basic documents which are required for the filing the central or state license. So I'll not take much of your time, but I'll just quickly tell you what is important here apart from the generalized set of documents. For if you are an importer, then you need to, the basic eligibility criteria is the IEC code, which is issued by the DGFT. Without that IEC code, you will not able to apply for import or export license with FSSAI. And there are many other documents which are being given here. If you see, if you are into meat and meat processing, you need a NOC from the municipal corporation. And then there are other documents, generic documents. And if you are a relabeler, let's say if you are getting your product manufactured from a third party in your own brand, then you will be called as a relabeler because the marketer category has been removed by FSSAI and it has been replaced with relabeler, where you need to take a NOC from the respective manufacturer, then also the product details, upload those details, and then you will be able to get your relabeler license. So what will happen? The manufacturer where you are actually getting your products manufacturing from the third party, their license will be linked to your license, so that FSSAI and the authorities will have a clear picture that the products which you are getting manufactured from a third party is having a requisite license to manufacture that, and you are complying to the respective provisions of the law, because finally you are the brand owner and it is your primary responsibility to ensure the compliance of the law apart from the manufacturer, because brand owner or a relabeler is treated as a deemed manufacturer because it is your baby and you are getting the product sold either in offline market or online market, or it's a combination of both. And another important thing is basically the renewal. You can do renewal before 120 days from the renewal date, and if you don't do before 30 days, then there is a penalty of 100 rupees per day of delay in the filing. So ideally you should actually file before 60 days so that your renewal license will come on time. So this is the schedule 1 of the central licensing. Here if you see, I'll just quickly highlight on 2-3 main important categories. Like import we have already discussed. Apart from that, the non-specified categories also fall under the central licensing. Then the newly introduced category, as I explained, the nutraceutical category, as per the September order of last year, that you have to now apply for the central license irrespective of the capacity or turnover. And the people or the manufacturers who are doing radiation processing for their products, like for your mangoes or for onions or for any other, or even for some herbs, people are doing radiation. So those manufacturers also need to obtain this license from the central authority only, irrespective of their turnover, irrespective of their capacity, by virtue of the sensitivity of the products and impact on the consumer. And also food catering services, establishment units under central government agencies like railways, airport, seaport, defense, like what we have discussed. And apart from that, you will see the 100% EOU, which is EOU is nothing but export-oriented units, where you only need to take a 100% EOU license from FSSAI, and if you are doing both domestic and export, same product, then you have to take a license in the export manufacturing category. But you have to comply to the respective law of that particular country where you are exporting. You don't need to comply with the requirements of FSSAI for exporting the products except the license. You need to comply with the exporting country requirements. And another important thing is, so here what you have, if you see the 5th point, which is very important, so the 2 metric ton per day capacity is covering all the standardized categories, but except grain, cereals and pulses milling unit, where even if your capacity is more than 2 metric ton per day, still you have to obtain the state license only. This is a specific exemption, I will not say exemption, this is a specific provision given in the licensing regulation, where if you are into grain, cereal, pulses, atta, maida and all those, you have to get a license from the state authority only. So these are the conditions of license. So any FBO, which is the food business operator, once he obtains the license, so these are the 14 major conditions or 14 conditions which you have to abide during your continuity of license. If you don't comply with any of this condition during your licensing period, there then you might get a notice or a query, then they will inspect. Then, if depending on the situation and depending on the severity of the non-compliance, in such case, even your license also can get suspended or can get cancelled. So the first condition is, this is very important, that we should understand this condition, because many times once we get the license, we forget what are the conditions, and then we realize that we have not complied. The best example is especially for the startup space who may not have a dedicated regulatory team, where they miss on certain things like annual return filing, and the testing of water, if you are using water as an ingredient, then the 6-monthly testing of your finished product as per FSSAI requirement, which includes the vertical standards as well as the horizontal standards like your heavy metals, pesticides, then your another thing, NOTS, which is not naturally occurring toxic substances and all. And you also need to comply with Schedule 4, which is basically related to the hygiene and safety as per the licensing and registration and regulation. Because many times you will get a notice or a query, or if the hygiene is not maintained, and if it is a very severe scenario, then even your license will get suspended. And another important thing here is the condition number 4 and 5 to be specific. The fourth one, if you are a manufacturer or a repacker or a relabeler, you need to have at least one technical person from a specific technical background, like a degree in food technology or a graduation with chemistry as a subject, or a dairy technology or microbiology or MSc chemistry, and all that background is already given in the regulation. And another important thing is the annual return. This is very important, that for the preceding financial year, you have to file your annual return. Now it has been made online in the First portal, but annual return, I will see in the next slide, is only for manufacturers, repackers, relabelers and importers, plus the export manufacturers. No one else, other stakeholders in the supply chain needs to file the annual return. So this is very important, and if you don't file before 31st May, then for each day of delay, you need to pay a penalty of 100 rupees. Let's say if you have filed on 10th of June, then you have to pay a penalty of 1000 rupees, like 100 rupees into 10 days. So this is very important, and many times if you miss, then during your renewal or modification, authorities won't issue the modified license or renewed license unless you have filed the annual return on the first portal of FSSAI. So this is what I was mentioning about the annual return. So every manufacturer, repacker, relabeler and importer, including the manufacturing export, who has got a license, they have to file the annual return before 31st May of each year for the previous financial year, preceding financial year. Earlier it was in physical, now it has been completely gone away, it is completely digitized, and you have to file only online through the FOSFOS portal as per the Schedule 2. And now, earlier there was a requirement of half-yearly return for milk and milk products as well as meat and meat products. That has also been now removed. Everything is annual now. And earlier it was a quarterly return for exports. That has also been removed now. From 1st of April of this year, whoever is in the business of manufacturing, packing, relabeling, manufacturing export, importers, including milk and milk products, as well as meat and milk products, and obviously the export, everyone needs to file the annual return only in the FOSFOS portal of FSSAI, which is Form D1, which has already been enabled in FOSFOS. You just need to fill the requisite details and submit it that. You will get an acknowledgement of filing the return, and you can also see through your own login. And as I said, for every manufacturing